it's scheduled for 10:30.
February 7th, Carol?
Yes. That's Monday of the week of the deadline. To give you some time to make sure you have your committee
Monday.
reports. It's Monday, yes. To repeat, if anybody is not going to be available on the 7th, which is the Monday of our deadline, and when we are going to exec all the remaining early bills, please let me know as soon as possible and we'll arrange for a substitute.
Madam Chair, the list of early bills that you sent us,
Yes?
approximately half of them, particularly the first ones, are showing March dates when you check them in the status.
They were showing February dates when I checked them, so I will recheck, but thank you for letting me know. That's,
I have the list if you'd like to know which ones.
sure, it's been known to happen, but I don't,
So you say February 7th?
February 7th, Monday. If you can't make it, let me know as soon as possible. That's why I'm reminding you now, so that there's time to make arrangements.
Yeah, we've got 4 bills. I mean, we could exec as well.
Okay. Being 10 o'clock, I'm opening the hearing on House Bill 1059, and I call the sponsor, Representative Fellows.
Thank you, Madam Chair. This is Representative Sally Fellows from Holderness. This bill deals with issuing licenses, and I filed this bill at the request of Director Courtney from OPLC, so I will turn it over to her to answer any questions.
Thank you, Representative Fellows. Director Courtney?
Good morning, Madam Chair, members of the committee. My name is Lindsay Courtney, Executive Director, Office of Professional Licensure and Certification. This bill is very important for public safety purposes. Right now, many of our boards currently lack a quorum, despite our best efforts to find qualified individuals to serve. And many of these boards have not delegated authority for the agency to issue licenses. And I would submit that no board has the authority to presently to delegate authority to deny licenses. We're also, so essentially with those boards that currently lack a quorum, we are issuing licenses by operation of law pursuant to RSA 541A29. 541A29 requires an agency to respond to an application within 30 days of receiving the application. Once we receive a response, it doesn't necessarily need to be the response needed. The agency has 60 days to act. And the agency that I'm discussing is our licensing boards. So what happens when the board does not convene a quorum to adjudicate the application? After 60 days, the application is granted by operation of law without regard to whether or not the individual actually meets the requirements for licensure. Obviously, this poses some significant safety concerns. I'll give you an example. For about 2 years, the Board of Hearing Care Providers, which has now been merged with Speech Language Pathology, did not have a quorum. So it was a great time for somebody who's unqualified to apply to become an audiologist, because we were just required to issue the licenses, even if they did not meet the basic requirements. So this bill really just clarifies that if the person does not meet the requirements for licensure, that the agency does have authority to deny it. I'd be happy to take any questions.
Thank you. I take it that your review of the requirements is things like education and not good moral character or some of the less obvious requirements some of the boards have?
Correct. my personal opinion is I do not like good moral character requirements because I think it invites subjectivity and bias into the licensure application process. We obviously would not be able to adjudicate that, so we would just be looking at whether or not they've met educational qualifications, hours, supervised training, you know, whatever the statutory basic objective requirements are.
Thank you. Senator Pearson.
Thank you, Madam Chair. To bounce off our chairman's question here, when you look at the requirements that are not subjective, does criminal background fall under that as something you look at? So we don't have someone coming in here from another state slipping under the radar who's got a rap sheet taller than you?
So the problem with criminal background checks is that unless it's the state can't categorically, and I should say criminal history checks, the state can't categorically, I think it's under RSA 332G, say if you've been convicted of X, you don't qualify. That is set forth in statute. So there needs to be a board or an entity that has a certain amount of discretion to determine whether or not they meet good moral character requirements. Unless the board had previously put into place some sort of matrix or standing order permitting us or letting us know who would be qualified after having a criminal history check. I don't think this bill would also allow us to deny licensure based on past criminal history because it's not clear in the statute who would qualify if you have a criminal history.
Can I have a follow-up? Thank you, Madam Chair. Specifically, what's coming to mind with me is the ability to teach in the state of New Hampshire has a fairly substantial paragraph on certain criteria that will deny someone the ability to have a teaching license. Do we not have that in other boards? I know you don't deal with teachers, but
Yep.
but from the OPLC standpoint, do we not have? Does this not found in any of the 54 boards?
It is not found in most of the boards because the boards have the discretion to review the criminal background check. So,
Yep.
so that the only thing that OPLC could do is say, yes, you have given us your fingerprints and applied for the check. That they can deny the license if you haven't done that.
Right. But right now, we're not allowed to deny any licenses, so I think this is a step in the right direction. But it certainly doesn't resolve some of those concerns.
Thank you. This is sort of related, and that is, do any of the boards, or for any of the licenses, are there other requirements which are discretionary or unclear, or the boards normally would need to get involved in making a decision? What sort of other requirements like that might there be?
So it always depends on the board because each board, and it also depends on the statutory framework, right? So certain practice acts grant to certain licensing boards carte blanche authority to come up with all of these additional requirements. I think the Board of Psychology is one of them. Certain practice acts have specific statutory requirements and they must stay within the bounds of those statutory requirements. We have strongly encouraged boards to eliminate subjective requirements to the extent possible. Examples would be essays, case studies, those types of things, oral interviews. The governor actually issued an executive order back in 2019 directing boards to review their processes and eliminate subjective requirements. So we strongly encourage that, but certain boards still have subjective requirements. And obviously, I'm not qualified to assess an essay of a psychologist to determine, whether that person is a great psychologist, which is why we much prefer exams that are based on objective criteria So to answer your question, there are subjective requirements that we would not be qualified to review.
Follow up. So does that mean that, for any of the licenses where there are such subjective requirements, you wouldn't do anything with it, and you would, if they met the other objective requirements, they would get the license under this? Is that your understanding?
That's correct.
Okay, thank you.
Representative Bailey?
Hi. When the licenses have been automatically rejected for lack of a board meeting, Do they at least get their license fee back?
No, licenses are not rejected for lack of a board meeting. They're automatically approved, even
Oh,
if the
okay.
individual doesn't meet the qualifications.
Thank you.
And no, we don't return the fee.
Correct.
Actually, if you apply for a license and the board delays the meeting, you're still on the hook for the fee, although it will apply for your first license. Representative Schuett?
Thank you, Madam Chair. Good morning, Lindsay.
Morning.
Excuse me, Miss Courtney. Can you give us an idea, is this instance that you're referring to where boards couldn't meet, an approximate percentage of the boards that this affected? Was it half? Was it mostly all, or?
It varies. I will say there are a handful of boards that currently lack a quorum. An example of medical technicians, they haven't met since February. The Board of Respiratory Care Practitioners, I don't even know when the last time they met. So we're just issuing licenses after 60 days. The problem with that also is that they've got to wait 60 days to get their license. And as you can appreciate in COVID, 60 days is a long time for a respiratory care practitioner to wait for a license. But that's, kind of a separate issue. So there are a handful of boards that are just not meeting. Then there are boards that, particularly in the healthcare, because they are actively working in the profession, that they'll cancel at the last minute, and there may be, like psychology, for example, had to cancel their December meeting. Somebody had to wait 2 months to get a license, that sort of thing. So they are consistently meeting, but there could be times where people fall in that 60-day window.
Thank you. I'm sure you're aware that some of the boards that you have proposed to members of this committee to make advisory, and I'm sure you're aware I've inserted language in several of them saying in consultation with the board for certain actions. Do you feel that that language would enable you to consult with, say, one member of that board to approve such applications?
Yes, so that's what we do with our current advisory boards, body art, massage, reflexology. We've established criteria that it's objective and clear, so that staff know what they're looking for, and there aren't any criminal history checks for those professions. But to the extent that there are questions, we consult with our advisory board members.
Thank you.
Representative Lakis?
Thank you. So is this problem of the boards not having quorum, not meeting, is something new, maybe related to COVID, or has this been a longstanding issue?
I think it's been exacerbated by COVID. It depends on the board. Certainly, particularly in our health boards, we're struggling. We've sent out email blasts. I've reached out to stakeholders. We're struggling to get people to be able to take time off work to come drive to Concord, and so we have seen that exacerbated during COVID. I don't see it really getting any better, to be honest with you. Given our healthcare workforce shortage right now, it's just hard for employers to give employees time off. What we're finding is we get a lot of people who have retired, who may be interested, which is great. At the same time, depending on how long it's been since they've actively practiced, you may not be getting that perspective that you'd like.
Okay, follow up? So outside the healthcare area, are there other boards where this has been an issue prior to COVID and continues to be?
Yes. Court reporters is another one. I think you'll see a bill later. They have 2 members. They're currently not meeting. We've offered to meet outside with them. They are not meeting, but there's only 60 people in that profession, so I don't know that we'll ever convene a quorum of that board. The technical boards seem to be doing better as it relates to a quorum. They also tend to be a little bit smaller. Some of our health boards are really large. But yeah, I would agree that COVID has certainly exacerbated this problem.
Thank you.
Representative Marsh and then Goley.
Yes, thank you, Madam Chairman, and thank you for taking my question. I'm wondering if these various boards were able to meet during the state of emergency when remote meetings were allowed, and would adopting a hybrid model where you could have a physical meeting place but members could attend remotely, would that solve your problem?
I think it would solve problems for most. There are boards that literally lack a quorum. Medical technicians is one, and they only have 2 members, which is not a quorum. And we've just received word that the other member plans to resign. So for most boards, I think that would certainly help. All of our boards went remote pursuant to the governor's emergency order. May 7th, we brought them back in, and we did obviously observe that there were issues with obtaining a physical quorum.
Thank you, Madam Chair. And I understand the difficulty. It's a small state, and some folks could have to travel an hour and a half, 2 hours to get to a meeting in a board they have been put on. Would it help to make it mandatory that those that have been put in positions have to attend a certain percentage of meetings? And how about making it a requirement that they meet so many times a year so that we can get this done, and if they don't show up for those meetings, that they will be replaced? And then the other thing, in talking to a few members here, maybe, I know a lot of places have alternates on boards that could fill in to make sure they get that quorum. I'm just thinking of a few things we could do to help out, because I think instead of making everything advisory, we should try and solve the problem we have of not getting quorums, and looking at the best way to get there is what I'm looking for.
Yeah, I think that would, I would support that. I think part of the issue is actually getting people to volunteer their time. That is, we have a number of vacancies. I send reports to the governor's office every other week, and we have a ton of vacancies. Actually, public members are very difficult to come by. I think part of the issue, right, that we're dealing with at the office is that, for example, I'm an agency head. All agency heads have to sign a power of attorney so that if, something happens, or you basically, the agency, the government can still function. There is no such contingency plan when these boards can't meet for whatever reason, and some of it is justifiable, of course. So when a board doesn't meet, literally that part of government shuts down. What is the state's contingency plan? The governor doesn't have authority, to just go in and license people. I suppose the legislature could convene quickly, but what we're dealing with right now is a lack of a contingency plan. Maybe the contingency plan could be alternates. I think it would depend on whether or not the state feels that that's sufficient. My main concern would be that in certain professions, we're just struggling to find board members. Maybe our boards are too large. I don't know. When you have to have 8 people to convene a quorum, that seems a little large.
That seems reasonable. Representative Grote and then Pearson.
Thank you, Madam Chair. Ms. Courtney, would you be able to give us a list of the boards and how many members are on the board to make a quorum, and the last date that they met? That way
Certainly.
we have
Yep.
follow-up. And what do other small states do when it comes to the licensing?
Yeah, licensure varies. I will say Vermont has moved to an advisory model. The majority of their professions are under advisory boards. The Secretary of State has direct authority to issue licenses. But each state has taken a different approach. There's about 22 umbrella agencies. And then other states, larger states, have licensing boards. Some states, the umbrella agency, there are no boards. I think Utah is one of them, and the state just directly regulates the profession through, I think, their Department of Labor. So it really varies.
Mm-hmm. Follow-up. So might it be possible for you to put together a list of contingencies based on what other states do that would fit our model?
Possible contingency plans.
Correct.
Yep, I can do that,
And
Representative.
last follow-up, I'm sorry, one more. I'm going back to the criminal, I'm sorry? I said your final follow-up. My final follow-up. I'm concerned about this lack of ability to use criminal record. So how can we address that? Because that seems an emergency to me. So how can we address that? What are your recommendations for that?
I think it depends on the board. I think we need to look at, for example, I believe medical technicians, which I think we're the only state to regulate medical technicians, but I believe we require a criminal history check for them. So, one response would be to just continue to try to find people to serve on the board to review the criminal background checks. The other option could be explicitly set forth, in statute, although you'd have to look at whether that conflicts with 332G as to who would actually qualify and who would not. 332G directs us to review a case-by-case analysis because under 332G, the right to pursue an occupation is a fundamental right, so it doesn't give us the ability to just carve out classifications of people who are qualified. But assuming the legislature can change 332G and wanted to do that, you could certainly have certain buckets, and then the other option is to have a contingency plan so that another regulating body can actually act.
Thank you.
Representative Pearson?
Thank you, Madam Chair. We've had a lot of discussion here in the last 10 minutes in reference to boards and their quorum abilities. With the actual legislation we're talking about in front of us, 1059, do you see any differentiation here between a board's inability to have members to make a quorum versus a board's refusal to meet as far as this legislation goes? Or do you read this as being the same, irrelevant to the purpose, just the fact is the board is not meeting?
Correct. I mean, we have some people who refuse to come in the building, and then we have some people that, for what I would consider to be justifiable reasons, just can't come. And then we have some can't. There literally is not a quorum. It doesn't matter under this bill. This bill is really just intended to provide a contingency plan if a board is not meeting that would allow the agency to deny licenses to people who are clearly not meeting the qualifications, because we have concerns that we've been essentially handing them out like candy for certain professions.
Representative O'Brien?
Thank you, Madam Chairman. Thank you for taking the question. I understand what you're trying to do here, and not so much against it, but just concerned if somebody, I know you have trouble with getting people there, but what happens when somebody objects to the licensee? And what is the procedure? Can they submit an affidavit or a report that will be read into the record for the consideration of the others in context of how this will work in the future?
So when you say if somebody objects, who would object?
Well, you get somebody applying for the license, let's say, and somebody is familiar with that particular licensee's case, and they cannot make the meeting. Is there a way that they can submit, if they cannot make the meeting, submit some form of a objection?
So certainly even when we lack a quorum, and I'll give you a true example. We had on, I think it was land surveyors recently. They missed a meeting or two, and there was an applicant who was held up in the 60-day time frame, and they got the license by operation of law, or we told members of the board that, you either need to come in or this is going to happen. We had concerns from a board member that the person didn't meet the basic qualifications. Under the current structure, it didn't matter. We had to issue the license because there was no quorum. Under this structure, we could take the feedback, and provided that the concerns were they clearly don't meet this requirement set forth in statute or rule, we could deny the license. If it was just, I know this person, I don't think they would have good moral character, I'm not sure that absent a specific authorization by statute that we would be able to deny the license.
follow-up.
Follow-up?
I think what I was probably thinking about, you're doing the medical and EMTs in particularly. And so when they come for relicensing and everything, they do have a history, and what happens if one community did have some objection, and just following along that line.
It's a valid point. I think it goes probably less to licensure and more to disciplinary. So the other issue that this doesn't address, but the other issue is when boards don't convene a quorum, there's nobody to review complaints. And we do have some boards right now with just complaints out there that there's nothing we can do about it.
Thank you.
I have a question. Assuming that somebody applied for a meeting and a board applied for a license immediately after one board meeting, they're scheduled to meet every month, there's a snowstorm in the month, and the 60 day is the day before the next meeting of the board. And so therefore you issue the license on day 60, the board meets, do they have recourse to review the license and say, wait a minute, this person does not meet our qualifications? Or do they have to go into the disciplinary mode?
They do, because once you have a license, you have a constitutionally protected property interest that entitles a person to due process, notice, and an opportunity to be heard before you take it away.
All right, thank you very much. Are there other questions from the committee? Representative
Thank you, Madam Chair. So I can imagine you're also thinking in the background something that just has been occurring to me as I listen to the director testify. That is, those of us who are on the gel car realize that we also have a problem with rules which sometimes can expire. The gel car is not entitled to kind of pocket veto rules. If we don't act within the specified deadline, unless we get a waiver, which is doable, but you have to do it, the rule goes into effect. And so, and we've had situations, Chair, I'm sure is aware of it, in as much as she's been on the gel car with me for the last 10 years or so, that we have situations where rules come in and they get vetted. They go back to the board for some kind of amendment because the rule, a certain aspect of the rule is not acceptable to the gel car, and it sits there because the board is not going to meet again for X number of times. Well, if you have quorum problems, then they never get around to it. No, and I'm raising this with the chair because is this something where we may want to amend this bill a little bit to try to expand it to consider some of the options that
Representative
we've been
Schmidt, that's a
we've
very
been kicking
valid
around.
point, but it's more appropriate for an executive session.
Well, but she is the director of an organization that has a very large number of small boards, so I'm interested in her input.
Director Carr, if you can't understand what the question was, Representative Schmidt, if you could put it more concisely.
Would you, based on your experience with your boards, would you consider that there's some aspect of this bill which you would recommend expanding to facilitate the rule writing aspect along with the other stuff that we've been talking about?
Yes, I would consider that. I think that some concerns I would have is that we would receive a lot of objection to that. It is a valid concern. Court reporters, for example, is in the middle of rulemaking, and staff were trying to get them to convene a quorum in a parking lot so that they could vote on something, and they're not. So the rules are just at a standstill, and then when they expire, the agency can't do anything to enforce the rules. I think what you're getting at, though, is there are a lot of issues here. There's issues with occupational licensing that touches upon the structure that we have decided as a state to utilize. The current structure is not working. I'll tell you that right now. I don't know what the structure should be, but I think maybe that should be a larger conversation. I would have concerns attaching it to the bill because I think that the bill probably wouldn't move forward. And we have a significant issue right now where we're statutorily mandated to issue licenses to individuals who clearly lack qualifications for those licenses. And I would like to get that resolved. But I mean, I would certainly support a larger discussion, obviously, or as to what we should be doing with occupational licensing.
So the aspect that we're now discussing is one that occurred to me, and I wouldn't want to sink this bill by making it too much of a Christmas tree, but to the degree that we included a study committee, that's pretty unobjectionable as in terms of burdening the bill. So,
Representative Schmidt, we have a good number of other licensing bills, some of which are rather broad, and we can consider that issue in the context of those bills.
I'm glad to hear that, since I was wondering whether we had other vehicles.
We certainly do.
Okay, thank you.
Representative Pearson, did you have a question?
No, I just, it's more along the lines of I agree with the director here that let's not jeopardize 1059 for the sake of a broader deep dive that clearly needs to occur here.
Any other questions? Seeing none, thank you for your testimony.
Thank you for your time.
Is there anyone else who wishes to testify on House Bill 1059? Representative Infantine. Oh, please. Thank you very much.
I would have signed the paperwork.
It's an occupational injury, no question about it.
Madam Chair and Committee, my name is Representative Will Infantine from Hillsborough 13. I am also a member of the New Hampshire Electricians Board. And as I signed in, Madam Chair, whether I'm opposed or in support, I wrote "not sure" next to it. I would like to just explain a few of the things that were asked by your committee members here just in relation to the Electricians Board. We have always had a full board. We've had a full board for 10 or 15 years. We did not miss one meeting through COVID. We met pretty much every month or every other month as needed. First via Zoom, and then one of the first ones probably to come back in person. I am a public member. I'm not an electrician, so I serve as that individual. We have, it is very difficult, I'm sure, for the director because there are different rules for each committee. We, regarding criminal background checks, are discussing it now, but we haven't implemented anything. We do have a rule that says we cannot look back more than 10 years of a criminal history. So they have to fill out their application whether they've ever been convicted of a felony, and if they have, you know, we can't discuss it if it's been more than 10 years. We have utilized that on a few occasions where people were involved with trying to bring young women across, high school girls across state lines for nefarious reasons. And we denied that based on that. So it concerns me when we have a situation where someone is saying, well, we're not going to look at character. I'm sorry, I can't agree with that 100%. Now, in my 2 or 3 years on the board, we've had that one case that we felt that was appropriate. And again, we are trying to look into background checks because the Electricians Board currently does not utilize those while others do. The comment was made that what is going on right now is not working. I don't know if I take offense to that or not. It may not be working for certain committees, but it is working for others. Why do we do this? Why do we have these boards? Other states, it's dealt with by the government. New Hampshire, you know, the old New Hampshire way. We have members of our own peers in our own committees. People in our industry can better understand what's going on, whether we know someone just caught doing something they probably shouldn't have been doing, or whether they're a bad egg and they're doing something wrong in the industry. We have that ability as individuals. I'm concerned by this bill only in the fact of if you have a committee that is not showing up, well, that's a problem. That chairman and that thing that needs to be dealt with. But if the committee, if the administration gets so backed up that these things are automatic in 60 days, and we're not looking at and we're not looking at some of these character type things, I just see that pendulum swinging toward more of a government control and less of what we like to have it now. or members of our peers. Without question, there are things that go on with 50 or 70 some boards, I don't remember the number, that are very inconsistent. Now, this isn't the place to do it, to rewrite everything. Everyone's doing the best they can, especially under the circumstances. But my only concern as a representative, you do this long enough, we've all approved and voted for bills that the following year we have to come back and say, oh, we got to change that because we didn't think about that when we were the negative consequences. So I just want to make sure in the back of my mind, is this taking too much away from the boards and doing their responsibilities and basically saying, okay, hey, it happens at a certain time and that's the way it goes. Now, this is the electrician's board. Maybe we're a little more well-organized, maybe we're a little more aggressive and agitated and what have you. And I can't speak for all the other ones that aren't meeting. It is very disturbing to hear that some of these boards are not meeting, considering how much time and effort we put in to the board I sit on. So I'm sitting here, Madam Chairman, again, as I stated, I'm not sure whether I agree or not yet, because I don't know what the consequences could be. Thank you, Madam Chair.
Thank you for your testimony. Will you take some questions?
Yes.
Okay, Representative Pearson and then Grota.
Thank you, Madam Chair. I'm certainly not shocked that the Electricians Board is actually functioning as it should, considering the safety aspects involved. But if looking at the specific piece of legislation, especially on line 3, this is more of a triggering act in the sense that, in the event a board does not meet. So, this really puts the ball into the board's court in the sense that do your job and no problem. And, short of that, I mean, does that not satisfy your concerns in the sense of the OPLC taking over basically a board's function?
To be brutally honest with you, Representative, you folks deal with this a lot, and you understand the ins and outs more than I, as I understand more the ins and outs of labor than possibly if you were coming to my committee. So, as I said, I'm not opposed or against. I just want to make sure that all avenues are looked at to make sure this is not more of a movement away from this quote that was just stated, that this is not working, that it's not too much of a movement away from what the board's responsibilities are and toward the government taking more control. But yes, it is more pleasing to have that sentence in there than not.
Thank you, Representative Grota.
Thank you, Madam Chair. Representative Infantine, would you agree that the role of OPLC is to protect the public?
Boy, I'd have to think about that. Ultimately, I think it provides some order to all of the occupations that we have, and I would say underlying many of those have to do with safety. I would agree with that.
Follow up? And therefore, if the boards have the authority and they do not meet, unlike your board, and I believe that the director did say that trade boards have a better reputation than other boards on meeting, how would you recommend that this issue be resolved?
I'm sorry, Representative. We could sit down and have an hour-long discussion about some of my ideas of the OPLC and what should be done, but I'm not going to disagree with what, again, I'm going to keep saying the same thing, guys. I'm not in agreement or disagreement of this. I just want to make sure it's not an overreach.
Thank you.
Other questions? Representative Sytek?
Well, it could be that the electrician's board is a little more important than the board of hammock safety, something like that. But my question is this: does the electrician's board deny a license if somebody's had a felony conviction?
We have.
Why?
The example I just told you.
That kind of felony, okay.
We
Yes.
get people coming in front of us that have been convicted of mostly drug-related crimes where they were involved with a break-in because of that. They present to us how they were incarcerated, rehabilitated. They get usually something from a parole officer. They talk about the programs they've been involved with and how they're back on the straight and narrow. And, you know, we have to evaluate those things.
Okay. Thank you. Representative Infantine, would you be pleased to know that this bill actually changes the current law, which says that if you apply for any license, if the board does not meet within 60 days, you will get such a license. So that you could, for example, get a doctor's license from the Board of Medicine, regardless of your qualifications. And we're trying to stop that. Does that reassure a few of your concerns?
Yes, Madam Chair.
Are there other questions? Okay. Thank you very much for your testimony. We'll have to consider this.
Thank you. It's always good to be in front of ED&A.
Okay. Is there any other person who wishes to testify on House Bill 1059? All right, seeing none, I'll close the public hearing, and we have 5 minutes before the next one. bill to ITL, just as the subcommittee met, so.
Now we would have to do that.
It being 10:45, going to open the public hearing for House Bill 1018 relative to the Board of Medical Imaging and Radiation Therapy. Representative Goley, you recognize and introduce the bill.
Thank you, Madam Chair, and members of the committee. For the record, Representative Jeff Goley, representing Hillsborough 8, Manchester's Ward 1, and here today to introduce House Bill 1018, relative to the Board of Medical Imaging and Radiation Therapy. This was a request of the Director Courtney of OPLC. So with that, I will turn it over to her to further dive into what the bill entails.
Thank you, Representative Goley. Seeing no questions, thank you for your testimony. Who's next? Ms. Courtney?
Thank you, Madam Chair, members of the committee. Again, for the record, Lindsay Courtney, Executive Director, Office of Professional Licensure and Certification. As the committee is aware, we are the state agency charged with providing administrative support to approximately 50 boards that have independent regulatory authority. And we also directly regulate 4 professions with advice of advisory councils. We've had a lot of discussion, I think, earlier about some issues at OPLC, issues with the boards, issues with the agency, and structure. From my perspective, for an occupational licensing structure to be successful, the state really has to leverage expertise of professionals in those occupations. There are some states that don't do that at all, and I think that you lose the ability to accurately protect the public if you don't actually know how to practice your profession. But you also need individuals who are well experienced at administrative law and procedure, and you need to marry the two together. So members of the regulated professions are certainly experts in their fields. They're generally not experts in administrative law and procedure. State officials may have vast experience in administrative law, but they don't know anything about a particular profession. So how do these individuals, how should they work together in order to ensure that the needs are met of the state? I think it has to be a harmonious relationship in order to achieve the state's mission of protecting the public. This structure really breaks down when a body is not able to or is not consistently able to perform its role in the relationship. And as you've heard earlier today on another bill, there are several OPLC boards that either do not have a quorum or are struggling to consistently maintain a quorum. This obviously significantly impacts licensure and the state's ability to protect the public. I truly think that most of these issues are due to the fact that our healthcare boards are comprised largely of individuals who are working in the healthcare field, which is experiencing dire shortages, and it's not for lack of wanting to show up and attend and participate. But those people are obviously desperately needed on the front line and not necessarily all the time in board meetings. I believe that changing those boards that are facing quorum issues in particular would permit board members to freely provide their expertise concerning potential regulatory changes and licensure and other matters, even if they lack a quorum. So for an example, my electrology advisory committee, the agency itself has rulemaking authority. For a long time, the rules had been expired, I think dating back to when they were a DHHS. We have not been able to convene a physical quorum of the committee, but I was able to have conversations with these committee members, and we were able to put together a draft and file rules that everybody was comfortable with, and government continue on. So when OPLC was considering which boards should potentially move to an advisory model, which is the model that many other states use for small professions, this board came to mind as it struggled to meet once the boards were no longer permitted to have remote meetings in May. The board did not hold monthly meetings in May and June. The September and November meetings were canceled due to lack of a quorum. But they have been making good efforts to meet, understanding that it's important. They did meet in July, August, October, and I think this past month. The agency wishes to protect the public by ensuring qualified applicants can be licensed in a timely fashion, and that the state has a mechanism to effectively regulate this profession. We've talked about contingency plans. This is one type of contingency plan to make sure that the state has the ability to regulate the profession. OPLC has watched healthcare board members struggle to take time out of their busy lives to attend board meetings, and I significantly appreciate their service. I've got people traveling down from Littleton. But we also understand that they're often needed elsewhere, and often with lack of notice. We are extremely concerned that if meetings are not consistently held, that some individuals may be improperly licensed or not licensed in a timely manner, and complaints will not be addressed. We do have boards that have complaints, as I've noted, that are not being adjudicated. So I think moving this certain boards to an advisory model would permit the state to leverage the board members' expertise while ensuring that the state performs the duties it's required to do in order to adequately protect the public. And we certainly think that the MRT board fits that bill. Thank you for the opportunity to provide comments. I'm happy to answer any questions.
Thank you. Representative Pearson, you're recognized.
Thank you, Madam Chair. In looking over this, and this is directed to you and to both Representative Goley and McGuire to think about here. When we changed the definition of board on page 1, line 3, to make it an advisory board, that's all well and good. But when you go through the rest of this bill, the word board is struck out of everything. So we changed the definition of board, and then we removed the word board from this particular area of regulation. So I'm on the surface, I see that as potentially a fundamental flaw here, in the sense that you've created you've now changed it to an advisory board, but the advisory board now has no function, as it's been struck out and changed to executive director everywhere.
So I would disagree. This is the statutory framework for our other advisory boards, in the sense that the agency itself has regulatory authority, typically with consultation, and we would certainly support a change that would require consultation with advisory boards. But the advisory boards that we currently have don't have independent regulatory authority, and that there's typically a statute that sets forth what the advisory board is supposed to do. And you can see that in line 21, the advisory board shall advise the executive director regarding the implementation of this chapter. If we retained the board language in all of these areas, like 24, for example, if we retained the board shall adopt rules pursuant to RSA 541 relative to yada, 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 we wouldn't exactly solve the problem, because we would still need to convene a quorum of the board that may or may not be meeting.
In that particular area, I can clearly see your point there. It's just in other areas, it seems as though you have an advisory board that has no authority to advise anywhere, because you've removed them from everything. That's just, I'm trying to get a sense of, and you're doing a good job explaining it as to what this picture looks like now.
Yeah, I think it could probably be better described. It's certainly described in lines 20 and 21. Shall advise the executive director regarding the implementation of this chapter. There certainly could be parameters around that, you know, the executive director shall call a meeting X number of times a year or whatever, to make it clearer as to their function. Because I certainly think that, like I said earlier, we need to essentially marry the two functions together. We need to carry out the functions that the state has directed us to do, but we also need to leverage their expertise. And that has to be an important part of any regulation of any profession.
Representative Schuett?
Thank you, Madam Chair. This is sort of addressed to who I think will be the chair of the subcommittee that may look into this. We had agreed, the four of us, Representatives McGuire, Goley, Schmidt, and myself, to co-sponsor most of these advisory board possibilities. This one you see does not have my name on it, so I didn't see the language until after the bill was technically made public. I went through the bills that I sponsored primary, and in various places where it required decisions about education, administrative rules, what have you, and changed the language to say the executive director in consultation with the advisory board, which I think enables the board to still be the one making the considerations. And I would propose that this bill be amended in the places where it does not specifically inhibit the
Representative Schuett,
administrative duties.
I think we might be going down a rabbit hole of this might be better discussion for our
Well,
executive session.
I'm stating this to
or-
then say to the person testifying, would that be agreeable to you?
Yes, absolutely.
Thank you, that was my point.
Thank you. Representative Sitek and then Representative Marsh.
I think now my question is redundant because the Representative Schuett's in consultation with, I was going to ask, why not just put or? Instead of striking, just put or.
Yeah, you can, I mean, I think the issue, right, is who decides or. We've had issues at, I'll give you a prime example, body art. There needs to be some sort of veto capacity. The board had sought legislation to allow other members of the profession, of the cosmetology profession, not body artists, to perform microblading. So we pursued that bill, but when it came time for rulemaking, they received a lot of nasty grams from colleagues who were concerned that bringing in additional individuals would compete, basically put them out of business. So the body art board turned about face and said, well, we don't want to do this anymore. And I was able to direct them, no, we have this regulatory requirement, we need to move forward. If it was an or, I'm not sure we would have actually been able to accomplish that. So I think there always needs to be somebody who can act.
Representative Marsh?
Thank you, Madam Chair, and thank you for taking my question. I think my questioning is following the same lines as what Representative Schuett was going at. I'd like to look at page 3, line 28 as an example where it's discussing the educational qualifications of these people. And I'm wondering if you truly believe the executive director by herself or himself could set the criteria and standards, or would that very specific instance where it's a clinical decision and the input of the board is actually exceedingly valuable, if we should in every one of those places change it to executive director in consultation with the board, whereas leaving all the administration functions strictly with the executive director?
We would support that.
Thank you very much.
Do any other members have any questions for Ms. Courtney? Seeing none, thank you for your testimony.
Thank you for your time.
Are there any other members from the public that wish to testify on House Bill 1018? Representative Schmidt?
get you a pink card when I'm done. So, being on the bill, as had been noted with regard to Representative Schuett and Representative Goley and Representative McGuire as well, we have a series of these bills that we're hearing today, but I'm sure that the committee has been getting a deluge with emails with regard to one of the subsequent bills where the public is very concerned about stripping the board members out of any authority. And so I just want to say that in the whole process of putting these bills together, in consultation with OPLC, the four longer-serving members of this committee have been willing to consider the idea of restructuring the nature of the relationship between boards and the executive director, but always the underlying idea was to have the executive director and the OPLC do the administrative end of things where they have expertise, and the board retain their authority with regard to the niceties, intricacies, and guts, if you will, of the profession where they have the expertise. So kind of like, as I like to say, the left leg does its job, the right leg does its job. That's what we call walking. You have to have at least two legs to be able to walk. And if you are crippled and have only one functioning leg, you may be able to hop like heck, but you can't walk. So what we want to do with regard to this concept we're trying to develop here is to have the agency function in a degree with regard to the administrative end of things, and the board members and the professionals to retain their authority, their influence, their oversight, and so forth with regard to the profession itself. And that's what this previous colloquy between Representative Schuett, Representative Marsh, Representative Pearson, and the chair have been attempting to do. I just want to emphasize that's a discussion that several of us that are on these bills have been having. So we are in full support of the idea of streamlining things and improving the function, but not in any way of taking the professionals out of their area of expertise, but rather to lighten the burden on them with regard to administrative things where they may not be all that knowledgeable. They may not have legal background, administrative background. They know their profession, and that's where we should emphasize their activity on the board. But in no way is my intent as a co-sponsor of this bill to be that the executive director will become the be-all and end-all, and the advisory, the board members, the professionals will be along for the ride, but have effectively no say. So that's a no-go on my part. So I being on the thing, I could not be asking questions from the side that you're on. So I've chosen to come up and testify. But so I hope I'm making it clear. We're going to be seeing this especially when we get to midwifery a little bit later in today's list. But I'll answer any questions people may have.
Representative Sitek?
It sounds like this will probably go to at least a tiny subcommittee. And do you think it would be a good idea to put in that the board can itself call for a meeting? Does the bill say that?
I think if it's going to go to a subcommittee, we ought to have a dialogue with regard to how we see this new concept as being most effective, because we certainly do not want to get into a situation where the advisory board is effectively powerless. They're just a gab fest or a coffee clutch. So I think your suggestion is as viable as some of the other ideas we've been floating here. You're welcome.
Seeing no further questions, thank you, Representative Schmidt. Are there any other members of the public that wish to testify for House Bill 1018? Seeing none, we will close the public hearing. We will be in recess until 11:30.
Okay, committee. I'd like to go into executive session if there are no obvious objections. Fine. And Representative Goley, you have a motion?
Thank you, Madam Chair. I will move that we, let me find this. Ought to pass on House Bill 1059.
Is there a second? By Representative O'Brien. Do you wish to speak to your motion, Representative Goley?
Briefly, I think we heard that currently there is no way for the director or anyone to stop handing out licenses if a board shall not meet and make a determination within a certain time frame on a number of licensures. And this addresses that issue and will give the director some oversight if this happens. So I think this is a positive move and hope everyone will support it.
Okay. Representative O'Brien, you wish to speak to your second?
Thank you, Madam Chair. There we go. Thank you, Madam Chair. Representative Cooley was quite eloquent. Not much to say other than I do believe the testimony of Director Courtney shows the need for this bill and thus supporting it. Thank you.
Thank you. Is there anyone else who wishes to speak? Representative Blackus.
Thank you. I think we're licensing way too many professions, and I think in a case where if the board can't even be, or people either aren't willing to be on the board or they can't even bother to meet, we should drop licensing for it rather than doing this. So I will be voting against this. Thank you.
Anyone else? Representative Schmidt and then Pierce.
I'll defer to Representative Pearson for the moment.
Okay. You know, the function of government, you know, as we talk about the word function is it has to function. I mean, as cheesy as that sounds. And when we clearly have a situation where government does not function, that does not serve anyone. It doesn't serve the people. It doesn't serve the professions. It doesn't serve the agency. It doesn't serve the consumer. It doesn't serve anybody. So, you know, those of us that have been on this committee for a while have seen time and time again where we have examples of the inability to function. So having this piece of legislation come forward to provide an avenue to intervene in some of the functionality issues, I think is a good thing. This is not a takeover. I call these trigger bills because, you know, in the event of, if an agency fails, if the main body doesn't do something, then action gets transferred. It doesn't strip the power away from a board as long as the board does its job. And I think that not only is this triggering bill not a takeover, but maybe it's a little bit of a kind of a kick in the seat to some of these boards to say, hey, You know, the fact that you wanted to be on a board, but yet you're not going to show up for the next 2 years isn't going to fly anymore. So I do support this, this broad effort here, and then, you know, we can get into the minutia of the 54 different boards as to whether or not those need specific either modifications or removals. But as a general overall broad ability to keep the state of New Hampshire running in regards to this, I think this is a step in the right direction.
Thank you, Madam Chair, and thank you, Representative Pearson, for your take on the issue. I also am sympathetic to the idea that if we have a the government being hamstrung by a refusal of a board to function, then that's not in the public interest, and we certainly should be trying to remedy that situation. So as I say, I'm fundamentally sympathetic to the idea. I guess I would have preferred if we had some kind of a subcommittee, frankly, where we could have kicked around the various different possibilities or ramifications here, because we are basically, enabling the government to go forward on virtually anything, and if we're issuing a license or a permit for some action, this is a jump off the cliff to some degree, if we have not had an opportunity to think through some of the ramifications, I'd say, of what might be done.
Representative Schmidt, you're confusing that with the bill we passed last year, where we said if the boards don't act, the OPLC will issue a license within 60 days. This is a restriction on the ability of the OPLC to issue the license.
Well, that's why I think I would have preferred, it's a question of yay or nay, I'm likely to say yay, but I hope we'll have a thorough discussion because this is pretty open-ended, and I'm just a little bit reluctant to proceed without having had that discussion. And here in executive session, we're already making a statement of ought to pass without exploring this a little bit further. That's all I'm saying.
While I agree enthusiastically with Representative Lekis about too many boards being licensed, and that shows in their in this quorum issue, I will be voting for this because it's a step in the right direction, because we are growing rapidly. Think about this. On Tuesday, Director Courtney told us there were 50 licensed boards. Now there's 58 today. So it's even in the past couple days, it's just exploded. I mean, it's just, wow, breathtaking.
That's a good point. Representative Goley.
Thank you, Madam Chair. And I just want to address the comments by Representative Schmidt about jumping off the cliff. I think this puts the rails at the top of the cliff and stopping the jumping. This allows the executive director to prevent someone from getting a license if they're not qualified. This allows that to happen. Currently, we're jumping off the cliff by handing out licenses if the time frame isn't met. We heard if you wanted to be an audiologist, during COVID was the time to go do it because you didn't need any credentialing. Just apply and you're given the license because nobody's reviewing them and the boards aren't meeting. This allows her to stop that from happening. This puts the rails up on the top of the cliff and it isn't jumping over the cliff anymore. That's what's important about this.
Thank you. Other comments? Representative Allegro?
I'm really torn on this one, and I kind of want to reflect or reiterate some of the concerns of Representative Lekis and Infantine. I'm not sure at this very second which way to go, but like Rep. Lekis, I worry that we create bureaucracies, and then we grow them, and then we bring them under government control, and I'm not sure that that's an improvement. So I just wanted to express that sentiment. Thank you.
Anyone else? Representative Pearson.
I would just like to once again reiterate that this is a triggering bill in the sense that this does not transfer authority directly to the administration of OPLC. It requires a board to fail to do its job before that occurs. So let's not confuse where authority is being moved. It's actually not being moved at all. The boards still retain everything here. It's just if they don't do their job, now we have a mechanism for government to continue to move forward.
Any other questions, comments? Okay, seeing none, I'd like to say I agree that it's the rail at the top of the cliff, because as the law stands right now, OPLC is required to issue a license to somebody that on the application form clearly does not meet the requirements, and they still must give them a license. I believe that's an unacceptable situation. Okay, anyone else? Representative Sytak.
Representative Schmidt, don't let the perfect be the enemy. Don't let the perfect be the enemy of the good.
Thank you for that sentiment. Representative Lakis?
Thank you. I understand why people support this, and I mean, there is an issue where if you give somebody a license without checking at all, in effect, you're putting the state's imprimatur on them as being okay when we haven't done anything. And I understand that concern, but my issue with licensing and all the professions we're licensing that I don't think we should will result in my voting no, although I understand it's going to pass. But thank you.
Representative
Thank you, Madam Chair. I would just point out to the newer members of this committee that we've put a lot of the restrictions on licensing people, particularly in the medical professions, in place after what happened at Exeter Hospital. If you're not familiar, there was a med tech there who, actually he was an orderly, I think, who ended up through misactions, which should have been caught through criminal records checks, ended up killing several patients at the hospital. And a lot of these protections were put in place because of that. But with the situation we're in right now, those protections are not being looked at necessarily. So I would hope that you would support this and give the the OPLC the opportunity to stop someone like that, at least temporarily, from
Actually, I don't
getting more.
believe that person would have been disqualified, because you'd have to look at the criminal records checks. And that's not something the OPLC is going to be able to do. He did have the technical
If I recall,
qualifications.
Madam Chair, he did have some
Yes.
bad reports from previous jobs.
Maybe. They just let him go. Yes, I think the issue of whether we should be licensing a profession or not is something that we will be discussing in great detail in the future and probably forever. But in this case, where we have regulated professions that can be granted licenses without meeting the minimum statutory requirements, is something that is, I think, a failure of the government. Any other comments, questions, discussion? All right. Having had the last word, the motion is ought to pass by Representative Goley, and the clerk can call the roll.
Representative Rhodes.
Yes.
Yes.
Thank you. Representative Yakubovich.
No.
Representative Lekis.
No.
Representative Allegro.
No.
Representative Bailey.
No.
Representative Santonastaso.
No.
I'm sorry?
No.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative Schmidt.
Yes.
Representative Marsh.
Yes.
Representative Fellows,
Yes.
Representative Grota,
Yes.
Representative O'Brien,
Yes.
and the chair.
Yes.
That's that too. 11-5?
The motion passes 11 to 5. It
Consent?
will not go on consent. Does anyone plan to write a minority report? Representative Lekes? Okay. That is due at your very earliest convenience.
You are writing a minority report.
All right. Representative Yakubovich, you have a motion?
Yes, I'd like to move House Bill 1273 forward for an ITL. This is the relative to the use of free and open source software.
Second.
Is there a second?
Second.
What was the bill number, please?
1273. Goalie.
Yes. So
Hey, Representative Yakubovich?
yes. So our subcommittee met this morning. We discussed the bill. The IT director was here. The sponsor of the bill was here. Some supporters. We went through the information I got from the director. I can send it to the full committee. It's very interesting. It's what his job entails. It's thousands of computers. It's 11,000 licensed end users for PCs. It's 2,500 mobile phones. It's 350 tablets, handheld tablets. It's a bunch of cloud services from Amazon and in the future Google, Microsoft, and Salesforce. And his department is running over $100 million every year. The budget for the department is $100 million. So I think the way I described it was I don't want to micromanage it necessarily and tell him what to use, whether it's a Dell computer or HP computer he has to buy. So this bill, as brought forward, is a very complex bill. It touches upon many different parts. We discussed it also that maybe it's a good idea to break it up and send it to various other committees because it talks about criminal justice issues such as the right to, face the accuser and question the devices used in criminal proceedings. It talks about restrictions on businesses. It talks about the council, the advisory council, that the sponsor wants to be brought forward to discuss open source. It talks about copyright issues, which I don't think the state gets involved in at all even. That's why we moved it to ITL. And the sponsor needs to work with the director and other parties and break it up and produce different bills. So thank you.
Thank you. Representative Goalie, do you wish to speak to your second?
Very briefly, knowing we have another hearing. I think Representative Yakubovich did a great synopsis of the subcommittee, and the agreement was that if there was 7 different portions of this, some dealing with criminal justice, others that might have been better off going to science and tech, that he bring this back and hopefully it goes to the appropriate committees. Thank you.
All right, thank you very much. Other comments, questions? Representative Marsh.
Yes, thank you, Mr. Chairman. I intend to vote in favor of this motion. That being said, and the reason why is because I agree this bill is not ready for prime time at this point in time. Many of us were first-year reps. It takes a while to learn how to write a good bill, but we've all been there. We've all done that. That being said, I do believe that there's substantial savings that we could achieve in the state of New Hampshire by increasing our use of free and open source software. A very easy to understand example would be using LibreOffice instead of Microsoft Word, which I think represents a substantial expenditure by the IT
Except
department.
that I believe the Department of Information Technology has already made that rather obvious step.
I understand that, but that being said, I think there is free and open source software and cost savings to be had, but this bill is not ready for prime time. Thank you.
There is another bill about open source software that is recommended to pass with amendment that might address some of your issues. Yes, I saw his hand, thank you. Representative Lekes.
Thank you. I agree with Representative Marsh. The only thing I'll say in addition is that it might make sense for, it may make more sense for the IT council to take this up, and as was mentioned during the hearing, it might make sense to, you know, put an additional rep or maybe change the membership in that, but that's a separate issue from this bill. So thank you.
Any other comments, questions? Okay, seeing none. The motion is ITL on House Bill 1273, made by Representative Yakovovich, seconded by Representative Goley. The clerk can call the roll.
Representative Rhodes.
Yes.
The clerk votes yes. Representative Pearson.
Yes.
Representative Yakubovich.
Yes.
Representative Alekis.
Yes.
Representative Allegro.
Yes.
Representative Bailey.
Yes.
Representative Santonastaso.
Yes.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative Representative Schmidt.
Yes.
Representative Marsh.
Yes.
Representative Fellows.
Yes.
Representative Groda.
Yes.
Representative O'Brien.
Yes.
And the chair.
Yes.
16-0.
The motion passed 16-0. Is there any objection to consent? All right, seeing none, we'll put it on consent. And thank you all for your efficiency. I think we will end the executive session, and thanks to the subcommittee for their prompt and thorough work. 2 minutes.
If we have a minute, I might mention to the committee the massages we'd like to talk. My subcommittee on massages, whatever that bill is, we'd like to meet after our session, after our hearings, late afternoon, after our hearings on Monday.
So, I'm sorry, was that originally for tomorrow?
No, tomorrow is
The COLA?
the COLA.
Okay, so the massage is Monday after our hearing.
Yes.
Thank you.
Subcommittees have to be noticed at least 24 hours in advance. So this is more than 24 hours in advance. It will be published, and it might make the calendar if you're lucky. Perhaps you should arrange for it. Public hearings have to be at least 4 days in advance.
You notice
Good morning. Yes. I'm resuming action and opening the hearing on House Bill 1330, and I call the prime sponsor, Representative Schmidt. You are not only the prime sponsor, you are the only sponsor, so I'm glad you're here today.
Thank you, Madam Chair. So I'm pleased to be before my favorite committee.
Oh, sorry.
That's as much as I'm going to grovel at this point. But in any case, I do like the committee, and after 15, 16 years, I've certainly gotten used to it. So I'm pleased to bring House Bill 1330 before the committee for its usual thorough examination of the issues. And this is one of these examples of a board that is being put into a new mode where the executive director is going to be the attempt, as I stated in the earlier bill, previous bill, is that we want to attempt to shift some of the workload more effectively from the board in terms of not doing certain administrative things that it perhaps does not have as much expertise in, and by the same token maintaining, and we may find that the language needs the same kind of modification that we've been talking about before, where things have to be done in consultation with the experts in the profession, so that we do not in any way kind of neuter the board and the practitioners in the process of governing them. By the same token, in conversations that we've had with the executive director and with some of the technicians over at OPLC, what we're seeing is that very often boards do not have the kind of, certainly the kind of legal and administrative firepower or background, or in some cases knowledge, that the OPLC has. That's why they have attorneys and administrators, and we want to get the walking process, to use my previous analogy, the walking process to be more one where each entity is doing the area and the activity and the operation that it has expertise and firepower, if you will, in, and not be doing something in which they are not so expert. But I'm hoping that, and I'm seeing the director here. I don't know that she's planning to testify. Can I momentarily? You are planning to testify. Thank you very much, Director Courtney. So with that, since I performed my most important task, and that is introducing the bill, I will defer to Director Courtney for her expertise on this particular issue. Thank you.
Thank you, Representative Schmidt. Oh, good, written testimony this time. Thank you. Call Director Courtney.
Thank you, Madam Chair, members of the committee, Lindsay Courtney, Executive Director, OPLC. This is currently a board that lacks a quorum statutorily. There are 2 members, and I believe one has indicated they intend to resign sometime this summer. So at present, they have not been able to meet since February of 2021. 2021. Sorry, not 2004.
Thank you, that seemed a little ridiculous.
And this is a newer profession. This is the Medical Technicians Board was fairly recently established. So certainly our concerns are that there's no statutory authority for us to deny applications if the individual is not qualified. It looks like that House Bill 1095 would resolve that problem. But the board cannot conduct rulemaking, nor can the board take disciplinary action because they do not have a quorum. The agency has received complaints, but there's no body that can act on such complaints. And as such, we're greatly concerned that the state is not meeting its obligation to protect the public, which this legislature has decided licensure is required in this field. Certainly changing the board to an advisory board is one way that would permit the agency to act in the absence of a quorum. The agency could seek advice of board members to evaluate complaints, register individuals, and deny registrations to individuals who are not qualified. Given the fact that essentially this aspect of government is non-functional, OPLC urges your support of this bill, and I'm happy to take any questions.
Okay, thank you. Before we get to the questions, I'd like to comment that this will be going to Representative Yakubovich's subcommittee for a combing of where we need to put in consultation with language, which after the previous discussions, I'm sure we need to specify exactly where you need to have their input before doing anything. So we don't need to worry about that kind of detail. Representative Marsh.
Thank you, Madam Chair, and thank you for taking my question. Commissioner, can you tell me how many states at this point in time currently license medical technologists? And I have a follow-up question.
My understanding is we're the only state representative.
Okay. My follow-up question is, can you tell me any circumstances where a medical technologist would be practicing independently, not under the supervision of their employer who may have credentials?
No, medical technicians it's my understanding they're required to act under supervision of a practitioner.
And one last follow-up question.
Follow-up.
Given those 2 answers, would you be supportive of a bill, if we amend this, to just simply repeal this licensure?
I would be willing to explore that. I'm familiar with the concerns, obviously, surrounding hepatitis C. I represented actually half of the plaintiffs in their lawsuits against Exeter Hospital, so I'm intimately aware of, I think, the knee-jerk reaction after that crisis or that issue. But I do think that the data demonstrates that if we are the only state that actually licenses these individuals, the state may need to take a further look as to whether or not that's actually required.
I thank you. And as a hospital trustee who was also interested in the knee-jerk reaction to Exeter Hospital, who believes that the hospitals are taking adequate precautions to protect the public, I would agree that this is not a necessary function of your currently overworked department. So thank you.
Thank you, Representative Marsh. I wish you'd been on this committee a couple of years ago when we faced the pleas to register medical technicians. All right. Are there any other questions? Representative Pearson.
Yeah, just reading through this, similar to the prior one, and I'll get specific, page 2, line 14. The fee for renewal is struck out of this, and I don't see because we've done this before with fixed numbers, right? We've left that to the discretion of OPLC to make sure that we have fair and adequate renewal fees across the 50 to 58 boards, depending on what time of day it is. So with this being struck out, I don't see a mechanism in place to have it mirror what we've done in other places. Is that covered by another piece of statute, carte blanche? and that's why that's not in here, or do we need to fix that?
Yes, it's covered by RSA 310A:1-E, which grants the authority to the executive director to promulgate rules regarding fees.
Awesome, thank you.
Other questions, comments? Well, congratulations, thank you very much.
Thank you for your time.
Is there anyone else who wishes to testify on House Bill 1330?
Before we close, Madam Chair, I was wondering if we could do something a little out of the ordinary here. It seems that there seems to be an opinion here as to whether or not this board should even exist. So perhaps we should have some sort of discussion in reference to that, because sending this to Representative Yakubovich's subcommittee to tweak it may be unnecessary if this is something we want to dissolve in its entirety.
I agree with you wholeheartedly, and I believe that subcommittee would be the best place to discuss that. And it would certainly be a germane amendment if they should decide to do so. Any other comments, questions? No? Seeing none?
Well, as long as you're asking for a comment, I think it's important for the newer members to understand that.
Point of order, Madam Chairman.
Yes,
I
it's not a
believe,
point of order. Representative Schmidt is in his teaching mode at the moment, which
I
is fine.
believe that if you recess the public hearing, then you could call an executive session and comments from our committee would be in order, but
You're correct. I was out of order
Thank
to
you.
call for comments. Is there anyone else who wishes to testify? Seeing none, thank you. I'll close the public hearing. Representative Yakubovich, I trust you will schedule a subcommittee meeting at your earliest convenience. Okay, and we are off until 1 o'clock when we get to meet with the midwives.
Good afternoon, ladies and gentlemen. It being 1 o'clock, we are going to open the public hearing for House Bill 1061 relative to Midwifery Council. House recognizes Representative Carol McGuire.
Thank you, Madam Chair and members of the committee. I'm Carol McGuire, representing Merrimack District 29, which is the towns of Allenstown, Epsom, and Pittsfield. House Bill 1061 is a request of the Office of OPLC, and I wanted to say, considering how much attention it seems to have gotten, that it is not an attempt to remove self-regulation from the midwifery profession. It is an intent to consolidate the administrative functions away from the board and have them concentrate on the professional aspects, such as evaluation of applicants, consideration of continuing education, and any disciplinary actions that might be required. And I know the bill does not properly address that in terms of where the executive director can act more or less on her own, first, establishing procedures and so collecting fees and things like that, and where the board needs to get involved for technical and professional issues. And therefore, I expect it will be going to subcommittee to deal with that. And if that is if the language is confusing or it doesn't express that intention, I hope it will not be taken badly if we correct it. And I'll answer any questions I can.
Representative Marsh?
Thank you, Madam Chairman, and thank you for taking my question. I would specifically like to ask you about Section 2 of the bill. And as a matter of background, while I'm a licensed physician, we had our last 2 children at home with a midwife. It was a very positive experience. But from that experience, I became aware of some of the tensions between the medical profession and the midwives. And my question relates to the advisory council established, where you're establishing a council with that will consist 2/3 of physicians or APRNs, whereas the existing council is 1/3 of physicians. And I would like to ask.
Actually, I believe the existing council is 2 physicians, one obstetrician and 1 pediatrician.
Right, 2 out of 6 members is 1/3 of the membership, whereas here
Correct.
it's 2 out of 3, which makes it 2/3 of the membership. So it seems to me that I'd like to know your rationale behind making 2/3 of the advisory council people who are not midwives.
That was not, as I said, this bill was a request of the Office of OPLC, and you'll have to ask them for that. I didn't make that decision myself.
Thank you, I will.
Are there any further questions from the members? Seeing none, thank you, Representative McGuire. The House recognizes David Lemieux. LaRue. Mr. LaRue, if you could accept my apology, I did not see the representative. Representative Schmidt?
As one of the co-sponsors, I wanted to speak beforehand because I've had some considerable conversations with some of the public, but also with one of the members of the current board, Ms. Stevens, several months ago, because, let me just say, first of all, for the record, Representative Peter Schmidt, Representative Stafford 19, which is Dover Wards 1 and 2, for the last 19 years and 15 years on this committee. So I want to assure the public that this bill is not intended to downgrade or oppress midwives or the midwifery profession in any way. Unfortunately, it has a couple of significant deficiencies that need to be addressed. I am fully in support of midwifery and have been for many years, although I've never had to avail myself of a midwife's experience. My daughter was born 56 years ago in Germany in a hospital. But in any case, the idea of the whole thing, and the committee has heard this before on some of the bills we heard previously, that the intention is to facilitate the professions that we are modifying in this fashion. We did not pick on midwives or pick on any other profession, but rather selected a couple of small boards where we could start off with the idea of trying to enhance administration for the benefit of professions where the board members may not have. Indeed, any board might have the same problem with members who are not particularly skilled at administration or in the law or whatever, but they are expert in their own profession. That certainly is the case with midwives. And so what we want to do is allow these members, one of the other bills is court reporters, for example, is also a small board, a small number of practitioners, enhance their ability to effectively engage in their own profession, but also to give the OPLC the benefit of their experience in their profession without burdening them with administrative or personnel aspects at which they may not be particularly expert or in the law. And so my understanding is this bill is going to a subcommittee where we will be addressing the deficiencies that are clearly manifest at an immediate inspection of the text, where it frequently just strikes out the board and substitutes the executive director. It's clear, and it was always our intention, and that the executive director would only be administering the board in consultation with the practitioners who have the technical skill, knowledge, and experience. So one of the things we certainly have established in this process is there's a lot of public support for midwives, and I rarely get such an inundation of emails in support of a profession, even if it very often was the same language. So and people don't have to write it in their own language. They were very manifest in their intention. So if there are any questions, I'd be happy to answer them. Otherwise, I look forward to hearing the testimony from the Assembly.
Representative Sytek?
Representative Schmidt, is the public invited to subcommittee meetings?
Public is not only invited, but they are entitled to attend subcommittee meetings. Our meetings are all public, and the public is welcomed and invited to attend because we benefit from what they can tell us from their own experience. I hope we'll have a lot of them present, because it's lovely to see all of them, and these young children, newborn babies in many cases.
Are there any other members that have a question for the representative?
Thank
Seeing
you.
none, thank you, Representative Schmidt. Representative Schuett?
Thank you, Madam Chair. I'll be very brief. As a co-sponsor of the bill, I became aware shortly after it was introduced that there were a lot of deficiencies in it. Among them, the membership and makeup of the board. I have had an amendment drafted which restores the 5 of the members of the board. It deletes the public member and re-adds the qualifications of the 2 physicians that are currently in statute. I would also say that we probably will be interested in amending the bill to add that phrase "in consultation with." However, I understand there's a large push. Most of the folks present here probably would like to see the bill killed. If that happens, if that's the opinion of the committee, fine. Otherwise, I have this amendment ready to present. That's all.
No questions. Thank you for your testimony. Representative Edwards.
I think it's on, yep. Thank you, Madam Chair. I'm Representative Jess Edwards, representing Auburn, Chester, and Sandown. 24 hours ago, I didn't know this bill was coming to committee, so I do not have any much technical guidance to share with you. But I did get a lot of calls last night, and I learned how to pronounce midwifery. So that was a big deal for me. I would say some of the public testimony you hear, I think, will be cautioned by just wanting to be polite and a little intimidated by the hearing process. And so you may not pick up on what I picked up on, and that is that there's a palpable fear that this is an end round, a trick to start to figure out how to kill the practice of midwives in New Hampshire. And I've talked to the prime sponsor, Representative McGuire. I don't believe that's her intent at all, but I did want to let you all know that there is that sort of fear in this community. One thing I heard that you all are in a good position to evaluate is that in the membership, they thought the participation of practicing midwives was underrepresented, and apparently there's at least two types of midwives. There are hospital midwives and there are in-home midwives, and apparently the point of view of each is sufficiently separated that the request was made to me to ask the committee to consider having one of each. So that's really my testimony. I have a lot of faith in this committee, tremendous technical work that I could never do. So I appreciate that you guys are laboring this.
Thank you, Representative Edwards. I also would like to take this time to apologize for mispronouncing midwifery at the very beginning of this hearing. Quickly realized my mistake. Are there any questions for the representative? Seeing none, thank you, Representative Edwards. Mr. Lemieux. Mr. LaRue.
Can you hear me? Okay. Oh, perfect. Perfect. Usually I speak without a microphone. David LaRue, I currently have a child on the way with a midwife, and I wouldn't want it any other way. You're darn right, there's a lot of fear. I don't have the technical aspects to speak about the midwife profession. I'm not registered, I'm not a midwife, but I trust them. Live free or die. I have to constantly say this phrase when I speak to councils and committees and people on the street. And it seems that we've forgotten really what that means. Again, how can we live free in New Hampshire? How can we live free if we're not able to be born free? Okay, you can't live a way that you can't start. And we already have a lot of problems with our society and with our system where our children, who we entrust these midwives to bring into the world, are born into a highly regulated and not free society. And the question that was asked right away, why is this new council being made up not primarily of midwives? That is a great point, and that's the first point to hit. And from the sponsor of the bill, it sounds like this was not the midwife organization and the profession coming and saying, hey, we need some help. This was an outside organization said, hey, those little guys need some help because they're screw-ups, and we can really help them because they don't know what they're doing. And so now we have this. And it used to be kind of a badge of honor. You know, I'm here in my coveralls and my rubber boots, and I'm from the country. And, you know, the old timers up north, we always used to hear, oh yeah, that guy, he was born in that house. Yeah, Grandpa, he lived and died in that house. They died in the house that Grandpa built. We used to have traditions, we used to have history, we used to have legacy. And in New England, we used to really have some grit and some determination. We're talking about legacy here. And what legacy does the midwife, the midwife leave? What is their part? We don't arrive at a stranglehold of tyranny via a decisive action. We don't arrive at an industry being a shell of themselves and a profession being hollowed out and losing all that makes them special. We don't arrive at that overnight through one bill. It's the death of 1,000 paper cuts. And people are right to be in fear of bills, especially poorly constructed ones, with good intentions. We hear every single bill, no matter what it is, well, it was made with good intentions. Well, I can tell you which road to where is paved with good intentions. Hospitals and the birthing industry is big money. And I don't have to identify the elephant in the room to say that we have some serious issues in our medical field and with people worrying about hospital care right now, worrying about what they're going to receive, what their babies are going to receive. The hospitals are a faceless industry for the most part. Midwives are an intimate experience. You don't get the relationship with a hospital. I don't care how many times you see your doctor. You do not develop the trust and you do not get to test the knowledge of the physician and the team that's going to be helping bring your child into the world through the hospital experience. You get that with midwives. I definitely think this needs more work. I would vote against it. I would say it needs to go back to the drawing board or be scrapped. And you guys need to let alone what has been working fine.
Thank you, Mr. LaRue. Mr. LaRue, would you be willing to take a question from a member of the committee? Representative Sitek?
Spell LaRue.
L-H-E-U-R-E-U-X.
I-E-U-X. Is there apostrophe after the?
No.
You don't use it? Okay.
Nope,
Thanks.
you got rid of that. You know your French a little bit, though.
Thank you, Mr. LaRue. The House recognizes Jordan Blessing. I think that's the name.
Thank you, Madam Chairperson. My name is Jaron Blessing. I'm a resident of Concord. I strongly oppose this bill. I'm also an attorney, and I certainly would never impute bad intentions towards the people who drafted this bill. But reading it, I read it yesterday for the first time, and it was clear it was either no thought went into it whatsoever, because I was extremely alarmed when I read it. It read as a clear desire to take over the practice of midwifery, take the decision-making out of their hands. As an attorney, we have professional boards that govern our licensure and our conduct. And if you were to tell me that you wanted to put a midwife in charge of that, I would say you are crazy. I think the similar thing applies. I don't see any good reason to give the executive director and attorney decision-making control over every aspect of the midwifery board. Thank you.
Thank you, Mr. Blessing. Seeing no questions, thank you for your testimony. The House calls Nicole Busford. Please correct me whenever you.
Buford. It's all right, you're not the first person to mispronounce that, and you won't be the last. Hello, my name is Nikki. I am a student midwife currently completing the PEP process to become a CPM in the state of New Hampshire, and I am also a doula running Sacred Sunshine Birth in Keene, New Hampshire. As this bill stands without any amendments, it threatens the autonomy of midwives in New Hampshire. Truthfully, home birth and midwifery in New Hampshire is already too regulated. Home birth needs to become more free, not less. Midwifery being under attack is nothing new, honestly. For the past 100 years or so, the over-medicalization of the natural process of birth has pushed midwives out of the birth process. So you can understand why we are fiercely against this bill as it stands without amendments. I fear that this bill, as many others have also stated that they also fear, that this bill will take autonomy away from the New Hampshire midwives. Our neighboring New England states of Massachusetts and Connecticut, no offense, put us to shame as far as birth freedom, women's rights regarding birth goes. I would like to see amendments to this bill removing some of the state's restrictions and regulations that we already have on home birth. I'm not sure if that's possible as far as this bill is concerned, but to start, we absolutely need to remove restrictions like BMI, not allowing vaginal births after cesarean, after 2 cesareans. In other states, these are allowed in the home birth setting, but for some reason in New Hampshire, they are not. For example, vaginal birth after 2 cesareans, an elective C-section before spontaneous onset of labor increases risk of maternal mortality 2 to 4 times compared to vaginal birth without induction, meaning that actually it is more dangerous to give birth in the hospital with an elective C-section than it is to give birth at home with an at-home midwife in cases of VBAC mothers. 6 per 1,000 maternal mortalities were with home births, and 100 per 100,000 were in the hospital with repeat cesareans. So those numbers are also coming from the MANA, the CDC, and the NIH and the NCBI. Breech delivery in twins can also be safely delivered at home. This is allowed in many other states, including Massachusetts, but for some reason it is not allowed in New Hampshire. Midwives know how to assist women in birthing their babies in a kind, gentle, loving, and safe way. Midwives deserve the autonomy to make the important decisions regarding midwifery. Again, like some other people have already stated, it doesn't make sense to put people that are not midwives in charge of the midwifery boards. We don't tell obstetricians how to do their job, so why are they telling us how to do our job? Hospitals, OBs, nurses, and even, yes, most certified nurse midwives don't speak the language of home birth or natural childbirth. It's ridiculous to have non-midwives outnumber midwives on a midwifery council. So again, I urge you to amend this bill or completely throw it out to give midwives the autonomy they deserve and to also remove discriminatory regulations from home birth. Thank you for your time. I will now answer any questions that you might have for me.
Seeing none, the House thanks you for your testimony.
Thank you very much.
Ms. Champney?
Hi there, my name is Natanya Champney. I'm a midwife in New Hampshire, up in Littleton area. I service the whole North Country. I'm coming to you today on behalf of the New Hampshire Midwives Association with an official document from them, which was sent to all of the...
Could you just spell your name for us? We didn't get any of that.
Natanya, Natanya. Last name Champney, Champney.
Also for you and for the other folks testifying, these microphones require that you get rather close to them so that folks in the YouTube world can also hear you.
Gotcha. Thank you. So I will state again that I am a midwife in New Hampshire, in northern New Hampshire. I run out of Littleton. I service the whole North Country all the way up to Colebrook and Pittsburgh. And I am coming to you today on behalf of the New Hampshire Midwives Association. This is an official document from our president, and I'm just going to read that. The Board of Directors of the New Hampshire Midwives Association, on behalf of our members, strongly opposes the proposed bill, HB 1061, as currently drafted by the executive departments and administrators. We have concerns that administering the powers and duties to a sole entity, the executive director, will be removing autonomy and the ability to remain a self-regulating body, as we have for over 30 years. Licensed midwifery has a long-standing ability to self-regulate, maintain responsibilities, and address disciplinary action. Placing this responsibility on a sole entity as the executive director stands threatens the ability for licensed midwifery to continue on as an autonomous, knowledge-based regulatory system, as it is impossible for an executive director to have a thorough understanding of the practice and profession without having experience in such. As it stands, the Midwifery Board is made of physicians, pediatricians, and peers experienced and well-versed in certified midwifery, ensuring that rulemaking, regulations, formalities, and disciplinary actions are appropriate and adequate to the profession, to the midwifery profession. Additionally, the amendment proposes removing the public member of the council. We feel that removing the midwifery consumer from the council silences the voices of the general public. And as we know, the voices are many. The midwifery profession has always put consumers, public, and community interests at the foremost of their work's purpose. To remove this position not only has a significant impact on the community we aim to serve, but also lessens the integrity and respect of the profession and the regulating body as a whole. As the New Hampshire Midwives Association, we are asking that this bill be repealed completely and that we continue to remain a self-regulating profession under the guidance and regulation of the current Midwifery Board. Thank you.
Representative Marsh?
The public person here will be willing to take questions.
Willing to take your question? Of course.
Thank you. May I ask a question, Madam Chair? Thank you. I suspect that I know the answer to this question, but I would like it to be entered into the record. We received a communication from OPLC concerned about the Sherman Antitrust Act and possible anti-competitive conduct by, due to the fact that there are only 27 active certified midwives in New Hampshire. It is my understanding that anti-competitive behavior tends to raise prices. Could you explain to us the approximate difference in costs to a family of having a home birth with a midwife versus having a hospital birth?
Well, from my standpoint, I take a sliding scale fee. I do not take insurance, and I am $3,800 for 11 months worth of care. And then a hospital, I believe that the hospital for a normal birth with no medication or anything is over $9,000 these days.
Thank you. I think that answers my question.
Okay.
Representative Judy?
Yes, thank you, Madam Chair. Just a simple question. How many midwives you have here in New Hampshire?
How many midwives in New Hampshire?
Yes.
I believe 27. 27.
I mean, the whole New Hampshire?
Yeah.
27? And how many schools do you have here?
In New Hampshire?
Yes.
There are no schools in New Hampshire for
So
midwifery.
How do you learn to become a midwife?
So you go to a accredited school. Well, there's two different paths that you can take, but one path is to go to an accredited school. There was one in Bridgeton, Maine for a long time. They have gone out of business, but there's other schools in the country that midwives go to, and then students go to, and then they come to New Hampshire to do their preceptorship with another midwife and follow under their direction until they have done the amount of births that they need to in order to become a midwife.
Madam Chair.
Follow up?
Yes. A midwife here, we never have any problem to deliver a baby?
Can you say that again? I'm sorry.
I speak too fast. If we never have a problem to deliver a baby, because, you know, at the hospital, there are some babies that come different way, upside
Right.
down, or...
Yeah, so the practice of midwifery allows us as midwives to follow women intimately during their prenatal time in order to make sure and to look at their history, make sure they are low-risk clients that are doing home birth. I mean, we have very clear ruling on all of this of how to determine who is acceptable for home birth and not. But may I just remind you that home birth is normal, and it's been normal for a really, really, really long time.
Oh, okay. All right. Thank you.
Yeah.
Thank you, Madam Chair.
Representative Sytek.
I'm from the city. I'm a little uneasy about midwifery, and I don't appreciate the education. I want to try to open the mind, as Representative Schmidt might say. My question is this. It's allied with Representative Judy. What happens if something goes wrong? What do you do about an RH incompatibility?
So we have laws that we have to follow as midwives in order to make sure that our clients are staying low risk at all times. And if they're not, then that is the wonder and blessing of having a hospital to have them go to if those things happen. But the rarity of those things is small in comparison to normal birth.
Well, thank you, I guess.
Yeah.
Representative Grota.
Thank you. I don't have a question about your profession or its standing, or my concern is with the board.
Yeah.
So when you have an application for a licensee, does the board approve that application?
As far as I know, yes, it goes to the council right now. The Midwifery Council is who regulates who becomes a midwife in the state, and it's done on a number of different criteria that the midwife has to adhere to, and that's how we get our relicensure every year as well. I'm not speaking on behalf of the council. I am speaking on behalf of the Midwifery Association today.
Okay, so thank you. I was going like this. So, do you understand that the concerns that we have to do with the board rather than your profession, you, home births, babies, and that the board has certain functions that it has to do, and if it does not meet those requirements, then things that could affect you as a group could happen. Do you understand that?
I understand that. I do not think that is accurate. As a midwife in this state,
Yeah.
I have put in my application for renewal time and time again. I have personally been late before, and I have gotten a phone call and follow-up, and I have never had any problems in them doing their job. It was more me trying to finish my part of the job as the sole midwife for my own professional certification. I have never had a problem with the Midwifery Council. I've never had a problem with them when we've had to administer. So if there is a infant morbidity or mortality or maternal morbidity or mortality in our, while I'm a midwife, you have to write out a sheet that says, what happened, and we always get phone calls from the council right away. I've never had a problem whatsoever.
Last question. So how does the New Hampshire Midwifery Association interact with the Midwifery Board, Council?
So we have a representative from the council that comes to the board to tell us any news that might be happening, which is how we found out about this. But the Midwifery Association is built so that we as midwives can come together and look at how we function as midwives and get information from each other, get help from each other, and really it's best for our communication and our furthering.
Thank you.
Okay.
Representative O'Brien.
Thank you, Madam Chair. Thank you for taking my question. Yes. In listening to your testimony, you said that currently there's a member of the public that is on the board. And I perused the bill and, did the homework and read it. But although I don't see it, but how would this bill change that public input?
So as far as as far as I know, so I'm not speaking on behalf of the council today, I'm speaking on just behalf of the Midwifery Association. But as far as we were told, the new advisory board that this bill is asking to be made up is only of 2 doctors and a midwife. And our current council has 3 midwives, a doctor, an OB, a pediatrician, so 2 doctors, and a member of the public. That is our that's our council right now.
Thank you for that clarification.
Yeah.
Appreciate it. Thank you, Madam Chair.
Representative Lekis?
So just to comment on that, Representative, the bill replaces the current makeup of the council, so the existing makeup, you'd have to go look at the existing RSA. Thank you.
Thank you for your testimony, Mr. Champney. The House recognizes Dr. Reinhardt.
Thank you, Representative Rhodes. I testify before you in opposition to House Bill 1061. My name is Dr. Heidi Reinhardt. I'm a medical doctor licensed in the state of New Hampshire. I'm a board-certified obstetrician gynecologist and practice at the Cheshire Medical Center at Dartmouth, Hitchcock, and Keene. I was appointed by Governor Sununu in 2018 to serve on the Midwifery Council. And previous to that, I served for 5 years on the analogous Licensed Midwives Advisory Board in the state of New Mexico. I chose home midwifery care for the births of each of my 3 children. I strongly oppose House Bill 1061. The enabling legislation for the certification of midwives in New Hampshire, Chapter 326D, states, and this is, I quote, "The intent of the General Court to preserve the right of women to deliver at home, to remove obstacles to safe out-of-hospital deliveries, and to assure quality of care." The bill established the Midwifery Council with powers and duties to certify midwives, to investigate complaints, and undertake disciplinary action. In addition, the Midwifery Council is charged with rulemaking for midwives' qualifications, scope of practice, and policies for professional direction and supervision. And it has been spoken about several times already, the composition of the Midwifery Council is 3 certified midwives, an obstetrician, myself, a pediatrician, and a community member. Lindsay Courtney, the executive director of OPLC, met with the Midwifery Council to explain that her goal in putting forth House Bill 1061 was to protect against allegations of anti-competitive decisions by the Midwifery Council, which we agree is a laudable goal. If I misrepresent what she explained to us, I'm sure she will correct me. It is in the interest of the OPLC and the state's interest that the Midwifery Council not run afoul of the FTC's commission or the FTC Act by acting anti-competitively. So here are the problems that I see with the House Bill 1061. First, the executive director of OPLC would be given all power and authority over the profession and practice of midwifery in New Hampshire. So it's absolutely appropriate that the OPLC be headed by someone expert in the legal and administrative aspects of licensure and certification. Absolutely appropriate. And it's also appropriate for the OPLC to monitor and guide the various boards and councils to remain within legal guardrails. That's not my area of expertise, and they will tell you I can get into trouble in terms of the legal part. I need that advice and counsel to stay in legal guardrails. But it is not realistic that an executive director of OPLC would have the expertise in the qualifications to practice midwifery, the scope of midwifery practice, and evaluating the competence or deviations from midwifery standards. And yet, House Bill 1061, as it's submitted to you all, places all authority in the hands of the executive director of the OPLC. The Midwifery Advisory Council, as outlined in the proposed legislation, would be unable to fulfill the mandates of the enabling legislation. One might argue that House Bill 1061 ensures appropriate input by the executive director by retaining an advisory council. But it would be composed of just one midwife and 2 other members, physicians or APRNs with experience in obstetrics. An advisory council is problematic for 3 reasons. Midwifery also involves care of the newborn in the perinatal period. There was no provision in the bill for input from a pediatric healthcare provider. 2, the history of medicine and midwifery in the United States has been less than smooth. Allopathic medicine, my profession, has traditionally been hostile to midwifery, and that's been the truth for about 140 years. And few obstetricians have any knowledge or direct experience with community midwives. The state and OPLC would be open to new charges of anti-competitive behavior if a physician-dominant advisory council attempted to curtail the practice of midwifery. 3, House Bill 1061 functionally obliterates the professional autonomy of midwives in New Hampshire by having only one midwife as the sole voice influencing the decision-making of the OPLC. There is draft legislation that was brought to the Midwifery Council at our last meeting. OPLC draft legislation dated 1/2/22. The amendment is not on the General Court Bill Status website, so I won't be able to address it specifically here. Representative McGuire referenced it. But it remains problematic because it imbues too much clinical guidance and authority in an executive director who is an attorney, or whatever the credentials are of the OPLC director in the future. Legislators, I stand before you committed to fulfilling the mandate of Chapter 326D on midwifery to remove obstacles to safe out-of-hospital deliveries and assure quality care. I oppose House Bill 1061 and urge you to reject it. I would be happy to work with the OPLC and legislators to shape a more acceptable bill. Thank you. Are there any questions for me?
Representative Marsh?
Thank you, Madam Chair, and thank you for taking my question. I have 2 questions. My first question is, would you believe that I am very happy that I'm not the only licensed physician in this room that chose home birth? My second question is more pertinent, and it regards your role on the council. Has the council had any troubles obtaining a quorum and doing its business?
We've had an illness recently that altered our ability to meet quorum, but no, generally, I've been on the council, like I said, since 2018.
And the illness is resolved now?
As far as I know.
Thank you.
Thank you. Oh, my apologies. Representative Grota?
Thank you. Could we have a copy of your testimony, please?
Of my testimony?
Yes.
Sure.
Thank you.
And how would be best for me to get it to you? Just hand it to you? Sure.
Representative Lekes?
And if you happen to have an electronic form, if you could just email it to the eDNA email address, so we'd all get it. Thank you.
I can show you where that link is.
Thank you. That would be wonderful.
Thank you, Dr. Reinhardt.
Thank you.
Sherry Stevens?
Hi, I'm Sherry Stevens. I live in Meredith, New Hampshire, and I am here on the, I am the council chair, the New Hampshire Midwifery chair. How about if I take one off? Is that better? All right. There you go. Better? Okay. Again, I'm Sherry Stevens. I live in Meredith, New Hampshire, and I'm here as the New Hampshire Midwifery Board Chair. I'm going to start with a question. I have a statement written by the council that I think you all were given. Would you like me to read that, or would you like me to just speak?
If we've already received that, we're okay just reading it. Thank you.
so I'm going to assume that you have read it.
I can't speak for every member in the room, but I do believe most of us have read the emails that were sent over to us. Thank you.
Okay. So the basic gist is that the New Hampshire Midwifery Council is in opposition of this bill for the reasons that have been stated previous, so I do not want to dwell on that. One of the answers that we've come up with the question is, are we, as the New Hampshire Midwifery Council, at risk for being sued or doing something untoward with not being administrative rule professionals? So our stand is that we would like to keep the New Hampshire Midwifery Council of 3 New Hampshire midwives with 1 obstetrician that is familiar with the practice of midwifery, and 1 pediatrician that is familiar with the practice of midwifery, and the public member. We believe that voice is very important. We understand the concerns of the OPLC, and our way of addressing that is that in order to preserve, I'm going to read this statement, in order to preserve the professional autonomy of the Midwifery Council and to achieve the goal of functioning within the legal barriers, we would endorse amending the language in this proposed legislation to reflect that the Midwifery Council continues to act autonomously with a consultation of the Executive Director of OPLC. And that everything that we do, we would ask for the consultation of the Executive Director or her designee. Therefore, we have the oversight that we think that they're seeking for our work. I did want to go back and address one of the questions I think that were given to Ms. Champney, that on RH negative. So in our, if you have an RH negative mother, the concern is that she would have an RH positive baby and have antibodies built up in her blood. And so in our formulary, we have the ability to obtain RhoGAM and administer RhoGAM to the mother. So an RH negative mother would be offered that at her 28-week prenatal visit, as well as obtain cord blood and decide if the baby, or determine if the baby is RH positive, and offer the mother a RhoGAM shot. Does that answer that? So I just wanted to make sure that we have a formulary in our law, in our RSA 326D, that gives us a formulary to address some of the concerns that were mentioned. What happens if there's something wrong? We are able to administer medications to help stem a hemorrhage. We are able to administrate RhoGAM for an RH negative mom if necessary. We are also part of, one of the things that was brought up is what is our certification process, and one of the certification processes and the recertification processes that we all are certified in CPR and neonatal resuscitation. So that addresses some of those questions.
Representative Grota?
Thank you. First of all, I want to commend all of you for coming here. And I know it's a bit scary, but you have to understand that from our point of view, you are the vital part of this process, the public. Mm-hmm. So I just want you to know how much we appreciate your efforts and your strength to come here.
Thank you.
So let's just talk about this consultation with the OPLC director or designee. How do you envision that happening?
So as Dr. Reinhardt said, the intention of the original RSA 326D, which in 81 was created to establish the profession of midwifery, and then in 99 we established the Midwifery Council. And the idea is that the Midwifery Council, like many other boards in the state, has regulatory control, and that we would have, there's a process, as most of you know, if we have a rulemaking, we speak to the rulemaking authorities from the OPLC, we work in connection to them. We've done it several times over.
Our rules come up, we work with them, and then we present it to GELCAR and it goes through. If we have a law change, it would go through the process. When we have, we certify and recertify midwives constantly. And so I, as the chair of the Midwifery Council, have for many, many years received those applications, vetted them, made sure that they meet all the requirements that are stated in the law and the rules, and then we would issue that midwife certification. And when OPLC came on board, and as we've worked with them, we've continually tried to work with them and say, here's our process, here's what we're doing, and they say, okay, here you have an administrator and we're going to help you with that process. They give us an administrator and they help us run our meetings. They, you know, if we have an investigation, they now have the enforcement part of OPLC that we work with. And we have been absolutely 100% willing to work with them, tried everything we can to work with them. We have consistently had different people come in as our administrators. So like we just get working with one and then a new one comes in, and it's just been a difficult process. But we're 100% dedicated to that process. We want it to work. We would love our meetings to run. I have attended the Justice Department's training on how to run a meeting, how to run an investigation since 2015. And we are absolutely committed to doing our job as purposefully and as legitimate as possible. So we have no problem working with the OPLC. If that is what their, in fact, I have that, their law was established to give administrative support to the boards. And so our law says we have our council to regulate the profession of midwifery, and the OPLC was created to give the boards that administrative support. Absolutely 100% agree with that. We're happy to work with them. We're not trying to do anything outside of that. But the state of New Hampshire has this wonderful autonomous board of midwiferys. We're very lucky to have that. It is not true in all 50 states. And so we are the state that most states look to and say, this is what we want. And New Hampshire, being live free or die and being the wonderful state we are, has created that, and the legislature has been very supportive of midwifery profession since the 80s. So we are very grateful for that. And we're not looking to change that at all. And so giving all that, all this autonomy to one person at the OPLC makes no sense whatsoever. If they're concerned about what we're doing, then please come into our meetings, which they do, and anything we do, we say, hey, is this the right way to do it? And if we're doing something incorrect, then correct us, please. You know, we want to stay within the law. Thank you so much.
Representative Marsh?
Thank you, Madam Chair, and thank you, Ms. Stevens, for taking my question. It's a great pleasure seeing you again after all these years. I'd appreciate a chance to catch up. Just to be clear, is it the position of the Midwifery Council that we kill this bill, or
Yes.
do you believe we can amend it in such a way to make it actually be useful?
It is the recommendation we kill this bill.
Thank you.
The Office of Professional Licensing and Certification, they're created to support the boards. And so us saying, you know, even us saying, you know, we, anywhere in our law that says the council is, you know, supposed to do this or that, adding with the consultation of the executive director seems redundant to me because it's already their job to oversee us, but we are happy to put that language in if that's going to give them security that we're not, you know, that we're following things correctly. Does that answer your question?
Thank you for your testimony. I'm not sure how to pronounce this last name, so if there's an Evelyn still here. Thank you, Ms. Asa. Yes, thank you.
Good afternoon. Vice Chair Rhodes, and members of the House Executive Departments and Administrative Committee. My name is Evelyn Asa. I'm a resident of Concord, New Hampshire. I'm here today to express my opposition to House Bill 1061. I'm here in my capacity as a private citizen and someone who benefited from the expert midwifery practice in our state. In 2014, I gave birth to my daughter Sabine at home under the expert care and guidance of 2 highly skilled New Hampshire certified midwives and their then apprentice. But I'm also here today because until last month, I served as the consumer member of the New Hampshire Midwifery Council, a position I was honored to be appointed to and hold for nearly 7 years. It's from these 2 highly informed perspectives that I find this proposed legislation unnecessary and, frankly, disconcerting. For 3 decades, the practice of midwifery in New Hampshire has been successfully regulated and overseen by the New Hampshire Midwifery Council. During my 7-year tenure on the council, we went to great lengths to uphold the serious responsibilities of our position. At the center of the council's work was and remains an unwavering commitment to the well-being of those eligible to seek a safe alternative to hospital birth. In recent years, the OPLC has made a concerted effort to better support the work of the Midwifery Council. We leveraged every aspect of it available to us as we carried out our work. That support was generally a helpful addition to the expertise of our members of our council, though it often brought delays to our processes and procedures, sometimes by several months, due to constant changeovers in staff roles, and an overall lack of clarity within OPLC about OPLC staff roles and processes. Nevertheless, the relationship between the council and the OPLC was, on the whole, a complementary one that allowed our expert council to ensure the highest standards for the practice of midwifery in New Hampshire and effectively oversee and regulate the profession. HB 1061 was drafted and filed by OPLC with no advance notice, no input, and no opportunity for collaboration with the New Hampshire Midwifery Council. It is an ill-informed solution in search of a problem, and one that has potential to fundamentally undermine the safe practice of midwifery in our state. This bill, as crafted by OPLC, proposes for midwifery in New Hampshire to no longer be directly regulated and overseen by the council. It also omits the public member's perspective, which we've discussed ad nauseum today. So what could go wrong in having the complex, historied profession of midwifery directly regulated and overseen by someone with no expertise in the field? Furthermore, as this proposed bill was introduced without any communication with or guidance from the council itself, it is also reasonable to question whether this proposed advisory board would have any meaningful influence over the decision-making and oversight of the executive director. So in the simplest terms, there's no need for this legislation. The New Hampshire Midwifery Council should continue to effectively lead in the direct oversight and regulation of the practice of midwifery in our state, as the council has done for 30 years. I urge you to vote in expedient to legislate, and of course I welcome your questions.
Representative Fellows?
Are you willing to take a question?
Sure.
From your experience, can you tell me how the OPLC staff interacts with your board? You know, are they there at every meeting, and
Yes.
what services do they provide?
Yes, I can say over those 7 years, or almost 7 years, that relationship has changed, largely in a favorable direction. So in the last several years, we've had a member of their staff present in every one of our meetings, taking minutes, informing our processes, providing us with sample language if we have to issue letters to midwives or otherwise take action. So it's been a very helpful relationship. As I noted, there have been some delays to our processes, some lag time oftentimes in implementation of things. But it has been a beneficial relationship, and frankly, I don't see a reason for completely upending it.
Follow up?
And just one other thing about your meetings. Do you feel that being able to hold virtual meetings would be a help or not?
I think it's extremely helpful, particularly as members of the council live all over the state and have considerable drive time. So yes, thank you so much.
Thank you for your testimony. Ms. Caponen?
Hi. Good afternoon. I'm coming today with nothing written. I'm coming with 40 years of experience as a traditional doula.
Excuse me, if you could just
Yep.
state your name for the record.
Julie May Koponen, Coponen. And I'm coming today as a mama of 9 babies, most homeborn, most of them 10 pounds. In my traditional doula work now, I said all mamas need is a mama in the room with them as they're laboring to know that here this mom has had many 10-pound babies at home. Works magic. So I'm coming with a little bit of, I said 3 minutes on my talk time. So somebody just kind of tell me. But I'm coming today with a little bit of a viewpoint from a home birth mama and from the home front. Like the young man who spoke about expecting his baby soon. Along with my 9 babies, we now have 29 grandbabies. And midwives have been catching them, and these midwives in New Hampshire are magic. Along with skilled, knowledgeable, experienced, amazing. Not only do they support their mamas, they support extended families in a lot of different situations, and always towards a healthier, more independent family life. I'm now looking at my grandbabies that are being born with the same midwife that they were born into the hands of. Now these grandbabies are coming into the same hands, and it's just beautiful. As I travel around the US of A, I've met a lot of home birthing circles, a lot of the midwives, and there is just no substitute for what this state has and the freedom that we have. And if I can say one thing about the small number of midwives, there are many more student midwives that interact with these midwives, that they support. And another thing is, please let the midwives be midwives with women. Those long drive times, I get that. Like, they don't need extra drive time, so if there's anything you can do to help, you know, simplify that so they have more time. Anyways, so I guess we'll leave it with that. If there's any questions, I'd be happy.
Thank you very much.
Okay.
Sandra Holmes?
Hello, my name is Sandra Holmes. I am a resident of Manchester, New Hampshire. I have had 2 children. My first was hospital born, and my second was at home with midwife assistance. HB 1061-FN robs midwifery oversight from people competent to set the standards of their profession, and it puts it into the hands of people not even competent to practice the profession. This puts the entire practice of midwifery into the hands of people who know nothing about midwifery and who have a vested interest in the practice ceasing to exist. Changing the composition of the Midwifery Council from midwives and their advisors to doctors and one midwife takes the midwives out of the driver's seat of their own profession. Taking all the power from the Midwifery Council and placing it into the hands of a single executive director is counter to New Hampshire's values. Powers should be vested widely across a large council, not concentrated in the hands of a single person. There is no need to change the composition of the Midwifery Council. 11 months ago, while hospitals were only allowing a single support person into the labor and delivery room, I gave birth to my daughter in my bed with my husband and my mother, with 2 midwives and my teenage son close at hand, able to meet his sister within moments of her birth. I would not have received that in the hospital. While hospitals were forcing mothers and their family member to wear masks through labor and delivery, my daughter was born into a room with her parents and brothers and grandmother's unmasked faces as her first sight. I wouldn't have received that in the hospital. My midwives ensured the health and safety of me and my baby, and they were able to whisk us away to a hospital if it became necessary. Giving birth in this fashion was my choice and my right, and it is the right of all women. The passing of HB 1061-FN can only lead to the reduction of the medical options available to women in New Hampshire. And that's all I have to say.
Thank you very much. Seeing no questions, thank you for your testimony.
Thank you.
Rebecca Price Wood.
Hello, my name is Rebecca Price Wood. I'm the owner of Sacred Transitions Midwifery, and we are the practice that manages the Monadnock Birth Center in Swansea, New Hampshire. I'm coming today to oppose this bill. My history as a midwife is starting out in Texas. I was a midwife there, I became a midwife there. I was also a midwife for 7 years in Louisiana. Served as the president of the Louisiana Midwives Association for 2 years. And then 5 years ago, my family moved up to Vermont, and I've been a Vermont licensed midwife and a New Hampshire licensed midwife for 5 years. I come to you today to speak from the perspective of a person, a midwife, who has practiced under a midwifery advisory council in the state of Louisiana. Midwives in Louisiana got licensure in 1984, and very quickly after that, we were managed by the Board of Medical Examiners with an advisory committee. This is how midwifery was regulated in that state until 1999, when, 2012, when the advisory committee was abolished by governor's order. So when I hear representatives coming in and talking about this wasn't the intention of the bill. This wasn't the intention wasn't to be an assault on the practice of midwifery in this state. I can tell you, and I think that you all know, that impact of bills and laws trumps intention. And ultimately, what is written in the law and what is written in the bill takes on a life of its own. We've seen this time and time again. I mean, this is not unique to this bill. So I'm urging all of you to listen to the voices of the constituents who have shown up here today, mostly women and their families. And I want you to hear that the impact of midwifery, any assault on this profession, is an assault on the constituents of the state that we serve. That's all I have.
Thank you very much. I must say, I drive past there every day. It would be nice to put a face with the building.
Me.
Miss Courtney.
Oh, jeez. Sorry. Just be COVID conscious. Thank you, Madam Chair, members of the committee. For the record, Lindsay Courtney, Executive Director, Office of Professional Licensure and Certification. I wish to start out by saying thank you to particularly members of the council who took time to come here. The amount of collaboration and respect that they've shown me in this dialogue, as well as members of the public. I think this has been a very useful dialogue and conversation. It was never my intent to impact the ability of women to receive care through midwifery or others. And I've had extensive conversations with the Midwifery Council. I had drafted proposed amendment that I circulated to them
which would effectively change the composition of the advisory council, as well as require greater collaboration in the statute. The concerns that have been raised are really, the one thing that's missing here, I think, is really the justification for the initial part of the bill. And it wasn't I'm just going to draw the committee's attention to my written testimony in which I laid out the United States Supreme Court's decision in North Carolina State Board of Dental Examiners versus Federal Trade Commission. I don't agree with that opinion. I actually agree with the dissenting opinion, but unfortunately there's no mechanism to appeal a decision of the United States Supreme Court, so it is what it is. And essentially what that case said was, when you have state regulation comprised primarily of active market participants, which is the model we have in New Hampshire, and obviously the General Court chose wisely prior to the 2015 case. When that happens, and they make decisions either through licensure or through regulation or through investigation of complaints, that decision is subject to antitrust scrutiny, and there is no immunity under the state if there's no state supervision, which we have none here. The state is absolutely 100% going to be sued at some point. I fully believe that, whether it's warranted or not. As a prior litigator, this bill is really intended to be proactive. We've got 27 licensees, so the risk is greater, in particular for this board, because everybody knows each other. I think there's probably more members of the public here than are actually regulated by the council. So I think we need to have this conversation with that backdrop. Of course, the Supreme Court recognized that the state is free to choose not to don on immunity under the Sherman Act, and if the state would like to keep such a model, then that's the state's prerogative. But it is a significant concern I have. It's a significant concern that I think we should all have, because I just want to play this out. If the state is sued by the FTC, and I have no doubt at some point that that will occur, the feds will file a lawsuit, and we will either be forced into some sort of consent decree where we completely take away the ability to regulate the professions in the manner that the state has chosen, or essentially it'll go to trial and the judge will choose to do the same thing. So that's really the issue. I would like to see New Hampshire retain its ability to determine what type of occupational licensing structure it should have. But at some point, I think, as we've seen in other states, North Carolina and other states, I think that we're going to be facing some challenges. I'd be happy to answer any questions. I'm sure there are some. I did want to note, though, the notion of an advisory council is not something I just dreamt up. We have that model in place here for certain boards already. That is the model that other states utilize, including Vermont. There is a way for the boards and members of the profession and members of administration to work collaboratively with each other to ensure that the expertise is appropriately leveraged, that members of the profession have an active voice in the regulations that are put into place, while at the same time providing sufficient state oversight to ensure that the state is not potentially risking any liability for any decisions that could potentially be argued or viewed as anti-competitive in nature. And whether they are or they're not, it doesn't matter, because as we all know, you can file a lawsuit against anything. So in any event, happy to take any questions. You have my written testimony. That's the crux of the gist of this bill.
Representative Lekis.
Thank you. So given those are your goals, I'm wondering how that led to the changes in the membership of the advisory council, which I saw as, and I think other people here have seen as one of the most concerning parts of this.
I agree. And I'll be completely honest with you, Representative, as I was with the council. I didn't fully appreciate the history there. Essentially, all of our current advisory councils have 3 members. So when drafting this, I just picked the different types of people that are currently serving on the committee. The amendment that I've drafted for consideration, I passed to the council, would expand that, include the pediatrician, the obstetrician, the 3 midwifery council members. I think it's important to note, though, that at some point, every licensee is going to be on the board, because there's only 27 of them. So I think that's why we wanted to keep it somewhat small.
Representative Marsh?
Thank you, Madam Chair, and thank you for taking my question, Ms. Gordon, here. I'm looking at the Supreme Court's opinion in the case of North Carolina State Board of Dental Examiners versus the FTC, and it appears that this case began when the board issued cease and desist orders to non-dentists who were providing teeth whitening services at a lower cost than the dentists were offering. Would you not agree that that is substantially different than what's going on with midwifery in the state of New Hampshire, where the midwives are providing their services at substantially lower costs than their competitors, being hospital births?
I would agree that case had different facts, but I do not agree that the FTC's ability to essentially look into antitrust matters or antitrust law generally is limited to those circumstances. And I can give you a long list of examples of observations we've made in board meetings where, and you'll see that the Supreme Court recognized that you can't, as a professional, and I'll say the same is true for myself as a lawyer, it's hard to take off that hat. And I think what the Supreme Court recognized is inherent in the ability to regulate, whether implicit or otherwise. You're going to be swayed by your personal experience, particularly as a business owner. This is more of a concern, right, when people own their own business. For example, if a board were to impose regulations limiting, let's say the dental board were to impose regulations limiting the ability of a qualified anesthesiologist to provide anesthesia services in a dental care practice because it would protect the public, but actually protect the business of the dental anesthesia providers, I think that's something the FTC could look into. And yet that's exactly some of the things that we've observed. So I don't think it's limited to the facts that were laid out in that case. I think there's a lot of soft decisions that are made that we see that are at times driven by the other hat that people are wearing. And that's not to say that these are people, right? They wear different hats. I wear many different hats. And I think that's what the Supreme Court recognized, is that it's very hard to take all hats off. And so there needs to be some state supervision in order for the state to claim immunity. I'll give you another example. I think I gave it to you early, the body art. Body artists wanted a bill to allow estheticians to be able to perform microblading. We got the bill. Then they got a bunch of calls saying, it's going to ruin my business. So they decided, we're not going to write rules. Well, there was sufficient state supervision because they're an advisory board, so I was able to say, no, we're going to move forward with rulemaking, and please provide me with recommendations. And they did. That's an issue that if we didn't have that model, they certainly wouldn't have regulated. And I have no doubt that the estheticians who are quite vocal, would have been concerned about that. Those are the types of issues that I'm talking about.
Representative Groda?
Thank you. This morning, when we heard House Bill 1059, which was related to creating the position of advisory boards for those, position of the executive director of OPLC, in consultation with the advisory board, for those boards that could not meet. How does this situation differ from that?
This situation is different in the sense that what motivated OPLC to pursue this bill was not a lack of quorum. It's more of just the really small size of the industry and or the profession, and the fact that I think because of its small size, it's at higher risk for scrutiny on an antitrust level. Everybody knows each other.
Okay, follow up, please.
Follow up.
Do we have any other similar boards that could fall under this issue?
Yes. You have a court reporter's bill in front of you, but that board actually has the two issues. They're not meeting as a quorum, and there's only 60 people who are regulated. One of our current advisory boards, Reflexology, there's also, I think, only 29 licensees, and so that's why that model works out well. The advisory boards generally tend to be smaller.
Thank you.
Representative Fellows?
Thank you. I have two questions. One of them is, aren't there any sort of laws in existence in statute, maybe not in the OPLC section, that protect the state against being sued for this kind of thing?
Well, they would be immune if there was state supervision. That's exactly what the Supreme Court case said, that the state officials who are arguably acting in an antitrust manner could be immune from suit and liability if the state had actively supervised them. And that means that somebody who's not part of the marketplace, a member of the profession, has the capacity to essentially vet their decision-making process. So that's exactly what this issue is about. In my opinion, there's no state supervision. Therefore, for our 50 licensing boards, if one of them were to make a decision or regulate in such a manner that could be perceived as keeping people out of the marketplace because they want to retain business, whether or not it's valid or not, the state would be liable. The state would be liable.
Representative Fellows, you're recognized for follow-up, but if you could please bring your microphone closer to you because we can't hear anything that you're saying. Thank you. Representative Likely, you'll be after Representative Fellows.
Why isn't it the staff that you provide legal advice and administrative support to the boards, why isn't that enough to qualify for supervision? And my second question is, can you just tell me the difference between a board and a council?
Regarding the latter, there's really not a difference. We've got boards, councils, and commissions. They all function in the same way. Regarding the former, providing assistance and administrative support to does not constitute supervision. Supervision, according to the Supreme Court, connotes some sort of ability to be part of the decision-making, I will say, whereas providing support does not. And speaking not specifically to the council, it's quite common for OPLC to provide legal advice, and that's not heeded. So, it's a concern.
Representative Lekes?
Thank you. Sort of related, I understand your concern. And so, what I'm trying to get, and I've got a question here, is how can we let the midwives regulate midwifery while having some state supervision to prevent them from getting in legal antitrust trouble? And related to that is, in the other language we had elsewhere where it says OPLC executive director can do something with the advice of the board, the question is, what does that really mean? Where's the power? Who has control over what?
So with advice of the board means that I have to seek out advice of the board, but ultimately the agency is the decision maker. That provides sufficient state supervision, but it also underlies the concerns that professionals have, which is that the professionals don't have complete control over the profession. So this bill is one way of threading the needle, so to speak, and trying to I think, meet justifiable concerns regarding liability. But I think that the council, members of the council, also proposed other language. I'm not sure that would. I'm not sure if that would actually satisfy North Carolina Dental's analysis. I'd have to go back and take a look. The agency is not, I mean, the agency will work with the council, work with members of the legislature in order to get to a point where all concerns are satisfied.
Follow up? So, you know, would it satisfy, do you think, you know, the legal requirement if there was some kind of language that said that that didn't give OPLC any control over the practice, you know, what's required to be a midwife or all that, other than specifically to that you know, you could provide legal advice on whether or not this conflicts with, you know, whatever the wording would be, you know, antitrust law, and that would be, they would have to heed that.
Yeah, so presently the state has the capacity through the Attorney General, right, to direct state officials to do certain things. In my experience, that doesn't regularly occur, because it usually has to get really bad in order for that to happen, and even then, I haven't observed that happen frequently. You could certainly have some sort of statutory requirement, but the issue that we're running into, and I'm not speaking specifically to the Midwifery Council, is that there are certain boards, a very small minority, that regardless of what the statute says, they continue to do something in contravention of the statute. I can't force somebody to do something that they don't want to do. So I think one thing the state could do under the Supreme Court case, the state could have a clear policy favoring anti-competitive regulation. I don't think the state wants to do that, and I wouldn't recommend it, but that would satisfy the concerns. You could have some sort of veto authority by a different body, whether it be me or the legislature, some other body that could review certain decisions. I think that would help. I think that would satisfy and meet the requirements for state supervision. I think there are a couple of different ways we could get there. But ultimately, you need somebody who's not a member of the profession who can essentially veto certain decisions. That's, I think, what the case gets at. And I think that's what the general court needs to be aware of, just generally with our structure.
Okay, I'd like to see if we can work towards that, whether it's through this bill or something else. Thank you.
Representative Grota, did you have a question?
Representative Leck has asked it, so that's great.
Representative Sitek?
Never going to get housebroken. This is actually a question prompted by what I've been hearing for Ms. Asa. Is she still here? You were on the council, right? And you were the consumer member. How many split votes were there? Well, okay. Thank you.
Seeing no further hands, the witness is excused.
Thank you.
At this time, we will close the public hearing for House Bill 1061. My apologies, I didn't ask if there was any other members from the public. If everybody would please accept my apology, I did not ask if there were any more members of the public that wish to speak, and we did have one. I'm sorry. I am reopening the hearing for House Bill 1061.
I apologize, and thank you all for the opportunity to still speak. My name is Therese Grinnell. I'm a registered nurse, and I live in Loudoun, New Hampshire. I come to you from kind of the opposite side of the situation as far as being part of a medical practice that is overseen by the OPLC. And all I want to say is, hearing that this is because of a concern that the state might be sued, we have to take a step back and look at what's really truly right for our patients, our mothers, and our babies. I can tell you right now what's happening in healthcare that is overseen by OPLC. There's over 60 licensed clinicians that Zoom call with that I'm a part of on a weekly basis right now that are feeling very, very tied to doing what they used to be able to do for their patients. For example, the autonomy to prescribe a medication. They actually have emails from their employers that say, if you prescribe this, you will be fired. We have patients that are in the ICU, and we're requesting basic interventions that were always protocol with a patient in the ICU for daily labs, right? You would think you would get daily labs in the ICU. TPN, total parental nutrition, for someone who's been in the hospital for over 6 days. They're not getting nutrition. Basic things that were always a practice of healthcare. We are now told, in a video by Dartmouth Hitchcock at 3:02, that if you do anything outside of what the administrators have deemed the protocol, you will be disciplined.
Pardon me, ma'am. Is this relative to the
It is.
Midwifery board?
Yes, it is. I'm getting right to it, I promise. Individuals who are practicing what's in the best interest of their patient in that moment are being stifled, and it's costing lives. So if we could somehow have the combination of the oversight to protect the state, like we do now, where they are collaborating, but you allow the autonomy of those providers to do what they need to do in that moment with their experience, when they've gone through the schooling, the testing, the licensure, and everything else, without now what's happening is the federal government is dictating what people can do in a way we've never seen before. So that's my concern, as we discern that these associations for midwifery, reflexology, whatever it might be, come under these umbrellas. The government overreach, in my opinion, and what I'm seeing in the last 2 years, has actually cost lives. So we just need to be aware that as we overregulate, as government overreaches, there is the potential for things to be done that are not done in a collective professional decision making, but rather in the fear of litigation. And that just can be very dangerous. Thank you for your time. I oppose this bill.
Thank you. At this time, I will close the public hearing for House Bill 1061. I didn't know.
We are, of course, 45 minutes.
I didn't ask if any
beyond
questions
the
because
time
nobody had their hand up.
We were scheduled to complete this bill. Fine, we are way beyond the time requested for this bill. The bill is going to subcommittee. All of you are welcome to send us your thoughts, or listen or visit the subcommittee and tell us what you think. I think I will not let you reopen it again. Okay. I'm opening the hearing on House Bill 1030, and Representative Edwards will present it. And if you are exiting the room because you're not interested, please leave quietly. Yes. You're presenting it? Oh. Thanks. My apologies. I'm recognized Representative Pearson.
I was happy to have Representative Edwards backing me up, but I don't know that he's stuck around. Which is fine. That's fine. Good afternoon, EDNA. I am, for the record, Representative Steve Pearson, Rockingham District 6 Dairy. House Bill 1030 is what we would call a repair bill. This is based on a piece of legislation that was passed in a prior session that inadvertently omitted two branches of the United States military. That was something that was discovered during the process, and frankly, we were told that the Senate was going to make those corrections, and they clearly did not. So all this bill does is it adds the Coast Guard and Air Force, Marine Corps, and Coast Guard into the list of military or Department of Defense branches that would qualify for the equivalency into the LNA field. I'm not entirely sure if the emails that came to me came to all of you, but there was some question in reference to the Space Force not being included. The medics in the Space Force fall under the U.S. Air Force. They do not have their own Space Force Medical Corps, so therefore they are not included because they do not exist. Beyond that, like I said, this is merely just a housekeeping bill to place the branches of the military back or into the statute that were omitted last year.
Thank you. Are there any questions? Seeing none, thank you very much.
Thank you, Madam Chair.
Representative Edwards.
Thank you, Madam Chair. Representative Jess Edwards, representing Auburn, Chester, and Sandown. I meant to be supporting Representative Pearson in his presentation of this, so there's some risk of some redundancy, but I've been following this bill with interest for a couple of years now, since it started with the Air Force and Army recognizing their medical training, their enlisted medical training. And we noticed kind of early on that the Marines and Navy had been overlooked, and I think it's just because the bill's authors hadn't understood how the Marines use the Navy corpsmen, and so it just got overlooked. And we wanted to make sure that that this bill could self-adapt over time. So we used the phrase on line 7, or others, meaning the Department of Defense, Space Command will be one of the Department of Defense, and however they in the next decade decide to staff their medic enlisted pool, whether it be Air Force or however they do it, this bill should be intended to be flexible enough to adapt automatically over time without rewrite. I'm a little uncomfortable putting things in there like a specific military occupational skill like 68 whiskey, because when I went into the Army many decades ago, those were called 91 Bravos. So I just would hate to see the law get weird because the DOD changes MOSs, but I think that's fine for now. We can just watch it. And I don't know what a 4 November 0 X-ray 1 is, but I did look it up on the internet, and it seems to be the correct nomenclature. I think this is really an important bill. We already passed the bill in concept last year. We want to recognize the military training and bring those young men and women into our healthcare provider professions.
Thank you very much. I agree with you completely, and I like that you've got or equivalent widely spread out through the bill so we can avoid having to do this again.
Yeah.
Any questions from the committee? All right, seeing none, thank you very much. Is there anyone else who wishes to testify on House Bill 1030? Okay, Seeing none, I'm going to close the hearing on House Bill 1030, open the hearing on House Bill 1427, and call Representative Fellows.
Thank you, Madam Chair. I'm Representative Sally Fellows from Holderness. Last year, when we passed HB 2, that included a section that combined two boards, the Board of Speech Pathology and, I'm not sure of the exact title, but the board that had to do with audiologists and hearing aid dealers. In the process of doing that, the language neglected to include an audiologist. So this is a correction to make sure that there's at least one audiologist on the board that oversees audiologists. So that's all this bill does. Any questions?
Are there questions from the committee? Seeing none, I thank you very much, Representative Fellows. Carolyn Drury.
Good afternoon, Representative McGuire and members of the committee. My name is Carolyn Drury. I'm an audiologist who has been certified and licensed in the state of New Hampshire since 1983 and have actively worked as such for 38 years until my recent retirement at the end of June last year. I am here to testify in support of HB 1427 on behalf of the New Hampshire Academy of Audiology. The purpose of the amendment is to have both an audiologist and a hearing aid dealer sitting on this board. As these are different providers by training and definition within New Hampshire state law. The RSA 326F, the New Speech Language Pathology and Hearing Aid Providers Practice Board, has merged the two so that they are now one board, but they have carried forward the definitions of the providers from the original RSA 137F. Just briefly to run through that, audiologists are college and or university trained in the auditory system, diagnostic testing and assessment of hearing disorders, and their treatment for both children and adults. This encompasses fitting of appropriate assistive equipment, including hearing aids. So our scope of practice includes that as well. Hearing aid dealers are simply trained to perform a basic test for the purpose of selling hearing aids. They are business people who do this as part of their livelihood. But the training is quite different, and we work in different areas. Predominantly, audiologists are in medical centers, doctors' offices. There are some who work in contracts with the school system for youngsters, and we also have private practice people as well. Hearing aid dealers tend to be in private practice or work for some of the large nationally franchised chains for hearing aids, and there's primarily business people, retailers selling these instruments. Don't want to go too much more than that. The other comment I have is I'm aware that the board has not actually met since its inception in July, and the New Hampshire Academy of Audiology, has provided 2 names for members, qualified members, to sit on that board, and as yet that position has not been filled. And we're a little frustrated by that, and we'd like to look forward to trying to get things moving along. Thank you for your time, attention, and consideration.
Did I understand you correctly to say that the board has not met?
The new board has not met.
and that there are qualified personnel have been recommended by your organization that have
Correct.
not been appointed to the board.
Yes, no one has been appointed yet.
Thank you very much.
You're welcome.
Are
Any-
there other questions? Representative Sytek.
You say that you have written testimony.
Yes.
And there are 25 copies. Are they handy, please? May I
Yes.
have them?
I've got all of them here. Do I just walk up and give them to you?
Other questions? Okay, seeing none, thank you for your testimony.
You're most welcome.
Director Courtney.
Good afternoon, Madam Chair, members of the committee. Lindsay Courtney, Executive Director, OPLC. This bill is pretty clear. This was a request that we made in order to clarify that both an audiologist and a hearing aid dealer should be represented on the board, as OPLC believes that professionals should have input into the regulation of their professions. I'm happy to take any questions if the committee has any, but other than that, I think this bill is pretty straightforward.
I do have a question. I noticed that you're making the board 6 members. So quorum is now 4, and you have the possibility of ties.
True. I think we would welcome an amendment to make it an odd number. But we're a little concerned with growing committees because we're already having issues with obtaining members. So we wouldn't want to make the committee so large. I suppose 7 would be okay. It's still pretty big, but given the profession, but obviously we would support an amendment to make it an odd number of individuals.
Thank you. Are there any other questions?
Thank you.
All right, seeing none. Is there anyone else who wishes to testify on House Bill 1427? Representative Fellows?
I just wanted to add one piece of information based on what we heard. I know that someone was nominated to be on the board back in, I think it was October. The governor made a nomination, but then for reasons we don't need to go into, that nomination was withdrawn. So, you know, just to show you that there has been an attempt to get more people on the board. And I could also share that there was some people, I heard from constituents that wished that there were 2 audiologists on the board, just in case one was not available. So if we want to increase the number, that would be one way to do it, make it 2 audiologists instead of 1.
Thank you, Representative Fellows. Are there other questions? Okay, thank you very much. Is there anyone else who wishes to testify on House Bill 1427? All right, seeing none, I'm going to close the public hearing. And
What am I doing?
you're chairing the
Cool.
meeting on 1016 because I'm a sponsor.
Sounds like fun. All right, good afternoon. We're going to open the public hearing on House Bill 1016, and I call the sponsor of the bill, Representative McGuire.
Thank you, Mr. Chair and members of the committee. I'm Carol McGuire, representing Merrimack 29, Allenstown, Epsom, and Pittsfield. And House Bill 1016 is an attempt to address a problem we found in the Medicare for Schools program, where it was determined that a fair number of the speech language professionals in the school systems were not actually licensed. Some of them were given, most of them were given temporary licenses. A good number of them qualified for a regular license. Some others don't. And those were primarily people that had different education. They did have quite a bit of graduate level training in various issues, but not necessarily the ones specified by the speech language pathologists. So this bill expands the eligibility to include people with that alternate education to get, so that they can get an appropriate license. And it was, I'm not sure if it was a request of GELCAR or the Department of Education or OPLC, but it was one or the other.
Very good, thank you, Representative McGuire. I'll start with, if you're willing to take questions, I'll just start with a simple one. Just looking at this, as it now creates a paragraph B and moves C back. So this is now taking the requirement of a master's degree and now allowing folks with a bachelor's degree to be licensed in this profession. Is that the essence of this?
No, sir.
Okay.
It allows people with a bachelor's degree in speech language pathology or similar, plus a master's degree in some other related field. For example, special ed, early childhood education, if you're going to concentrate on young children, learning disabilities, things like that, so that you have some training, the bachelor's level of speech language pathology, plus an additional master's in a related field.
Thank you for the clarification. Does anyone on the committee have any questions for Representative McGuire? Seeing none, thank you, Representative. The chair calls Laura Darling. I'll follow my own advice. Please turn, there's a button near the bottom. And there you go.
Oh, okay. My name's Laura Darling. I live in 58 Berry Road in Loudon, New Hampshire. I think I might be providing some testimony that I'm not sure if you already have, so I don't know if I'm going to be a little ahead of what you already know or what's in front of you. So my background pertains to my professional affiliations. Is I'm the past president of New Hampshire Speech Language Hearing Association, past president of vice president of governmental affairs, a past member of the Speech Pathology Licensing Board from the Department of Allied Health, and I also was a past member for the committee of the renewal of speech specialist rules with the Department of Education, and that was somewhere in like the mid-2000s. So that's what I've got for my background, and I was probably on the initial board for about 12 years, from about 1999 to about 2012, in these capacities that I just said. I am in opposition to this bill, and I'll explain why. I'm going to start off by showing you this chart that was put together by NISHLA, and it's got 2004 and 2007. And the reason why NISHLA, the New Hampshire Speech Language Hearing Association, put this chart together is because there was so much confusion among who a speech provider was in the public schools, and the different routes to or avenues to getting that certification or job in the school, so to speak, was extremely confusing to the consumer, the people who are parents of children who receive these services in schools. So pretty much everything here is similar. I have the qualifications for a speech pathologist who is licensed under the governing Department of Allied Health, the speech specialist under the Department of Ed, the alternative 4 that was offered and I think still is, as far as an avenue to get certified through the Department of Ed, and then speech language pathology assistants. The only difference on here now is that speech pathology assistants or speech assistants are now under the speech pathology governing board and regulated by them. At the time, this hadn't been official yet. It was pending. So that's different, and you can have this. Up here talks about all the different disorders or speech disorders and diseases and issues that people work with in the profession. And it's not just schools. It is in all areas. However, just to mention, the school population is just inundated or has a high population of severely impaired children that does require a graduate degree in the area of communication sciences and disorders and speech pathology. So these are significant disorders, and I have them all listed here. And I'll just, as a summary, there's things like neurogenic disorders like strokes, aphasia, swallowing, augmentative communication, and these are children that have these disorders and disabilities in schools as well. But this is from way back when, and because as president, I got routine calls from parents because they would find out after a while that their child was not being treated or serviced or through their IEP by a qualified professional. And that qualified professional or that qualified employee or that employee was the type of person that this bill is recommending to license. It was a person that had an undergraduate degree but did not have a graduate degree that is considered the highest level of standard with the American Speech Language Hearing Association and the Board of Licensure. So I don't know if you've, I got a memorandum that is from Vicki Chesterly that she had submitted. I don't know if you're familiar with it at this point. So I know she's going to be here to testify, and I went through her report, her memorandum, and I wanted to bring up some points that I have learned with the research I have done. And one of the points that I want to make on her report, is that Vicki is currently not on the board of the New Hampshire Speech Language Hearing Association. She has been, such as myself, but I have a concern that this is on the NISHLA letterhead. However, a NISHLA executive board member has not submitted this to this committee. I know there's an amendment that was done, and the Department of Ed is here to speak to that. And what I know about that amendment is because our national organization in ASHA saw that the original House Bill 1016, it brought grave concern because what it's about to do is bring this back to the convolution that everybody has dealt with many years ago. So a little bit of background that I want to clarify in the memorandum that you have is that, yes, in the 1970s, the degree program was clinically based, and certification or working in public schools was typical and accepted. Since 1980, a graduate degree and a master's degree in speech pathology or communication sciences and disorders has been the required degree. And this state has well over 1,000, if not more, speech pathologists who are who have that degree, who are working in the schools. So I'm saying 40 years has gone by where people who have a bachelor's degree had the decision to either get a graduate degree in speech pathology or they can go another route. And then there's criteria that I have down here to get admission into that program. So in the early 1990s, licensure was enacted in New Hampshire. So from there is when there was a divide. Some of the people who were already currently certified in the public schools were not going to, did not want to go under licensure when it was enacted in the early 90s. I don't remember the exact date. But they decided that they wanted to stay with the Department of Ed and be certified under there. And that is how the speech language specialist nomenclature came about, because they couldn't be called speech pathologists because of the other thing. So from 1996 to 2001, the University of New Hampshire provided a master's in science in teaching communication disorders due to the IDA requirements, so that the people who did have the undergraduate degrees but did not have the master's degrees were able to keep their jobs and sustain their jobs in the school. So here's the program. It no longer exists because it's just gone by. These people had the opportunity, or it was put there for that very reason. So here's the program that UNH had that was called the Masters in Teaching Program that would certify the SLS. Many people took advantage of that. Many people who took advantage of that program had a bachelor's degree. They got this degree, but that was well after the 1970s. We're talking about in the 1990s that people were doing this program, taking this program. So they're fairly recent graduates. But now we're talking about probably 30 years since licensure has been enacted, the qualifications and the criteria has been clearly established. And if you look in the licensing, there's thousands of speech pathologists here that are working. So this is not anything new. The undergraduate degrees, the people, they don't even really exist anymore. It's like a dinosaur. So this degree cannot bridge over into the American Speech Language Hearing Association to get certified. And that was as recent as a conversation with Susan Adams, who participated in the amendment, and just to clarify that, because I wasn't quite sure. So what I'm going to just talk about is that's one part of the memorandum to clarify those dates and what has occurred and transpired since 1970 to 1990 up till now. And then in paragraph 2, it states you can eliminate the endorsement that a licensed SLP and SLS have the endorsement of the Department of Ed, although it's not rigorously enforced. The speech language specialist rules that's here have on their RSA that anybody who holds a speech pathology degree, anybody who is a speech pathologist by the Governing Board of Speech Language Pathology shall be considered to have met the requirements. Never in my over 25, 26, whatever years I've been working have I ever had to get certified as a speech language specialist at the school. I've only had to have the speech pathology because that was the optimal certification to work in the school. So that's in here, and it's not a fact. It's not true. It doesn't have to happen. It's not something that has happened. The other part, one of the, to this memorandum, that was to require the meets, the requirements for that. On paragraph 3, I'm just stating that it says ASHA has objected to licensing these individuals. The individuals are these undergraduate people who this bill is trying to allow to be licensed with degrees that are maybe in reading, early childhood, special education, those types of things, not a Master of Science degree in communication disorders. And I'll just tell you my experiences as I see children, because I work with very young children, I work with all ages, but when they are not treated by a person who has the competency, they're not making the gains and progress. And parents don't even know who these people are or their qualifications very often. But to bring about allowing licensed people to, allowing these undergraduates to be licensed and then say they're licensed, now when parents are in an IEP meeting and they think this person is licensed, it's actually deceiving when they don't have the same degree and expertise and knowledge that the SLP has maybe in the district's next building. So this is very, very gray, and it's going to just confuse the public, and it's not protecting the consumer. So I am not in support of this bill because the educational and academic internship training is not the same as in an undergraduate degree with an educational master's degree described in the memorandum by Victoria Justilee. The CMS, Center for Medicaid and Medicare, their rules that you can review require that the person is the qualified person has these degrees. They have these higher degrees that I'm mentioning to you right now. That is by Medicaid for schools and Medicaid by the federal government. So I don't understand how a person with an undergraduate degree without the higher standard of the graduate degree is actually going to be able to fulfill the Medicaid requirement. Maybe it's something I need to learn, but I'm just going by the documentation from CMS and what they require. And Medicaid to schools only began probably in the late 1990s when I was working as a school SLP. So that has been fairly recent, meaning that by that time, these undergraduate people, whoever or where they are, if they were working under another capacity or with a different degree, a speech pathologist with an ASHA certification and licensure would sign their documentation for delivery of services, and the school would receive their Medicaid funds for that child. So, but it had to be signed off by the qualified provider, which was the ASHA certified, that I've said a million times that you might be tired of hearing. Anyway, so that is not new. I mean, this has been the past 30 years. I don't know where these undergraduates who from the 1970s are coming from, who are not where they are. I mean, hopefully they're retired, but in any case, you know, these people that the consumer relies on people who are in your seat to adhere that people are going to be protected and that they get the right service deliveries. The other thing is that I looked at the counterparts of my team members, which are occupational therapists, physical therapists, and they have pretty stringent guidelines for reimbursement for Medicaid, and there isn't anything that says that a physical ed teacher could do PT, Medicaid reimbursement, or something of that example. I think that it is a lot of progress, because I understand there's somebody from the Department of Ed that's going to speak here in favor of this, and maybe I heard supporting eliminating the speech specialist certification under the Department of Ed. And that I would wholeheartedly agree with, and I think that there should be less convolution, and I know that ASHA supports having only one body be in the state to be certified or the credentialed person for this position. But as I said, I was on a committee a long time ago. I know the Department of Ed has a lot of changes in there with different people who are no longer there. But my experience is that the Allied Health and Department of Ed have never worked together. I think it's going to be quite an endeavor for the Department of Ed to relinquish this certification, and I also know that they've held on to it, they've loved it, and I'd be surprised if this changes, but that would be a good thing. I don't think it should be at the expense, though, of licensing the undergraduate who I don't have the requirements for an undergraduate degree with me, but you can easily find them on the UNH website. But their coursework is just very basic, and their degrees in another area does not touch upon any of these criteria or disorders that are happening in the public schools. I have these papers that I can give to this committee, and I can leave them with you, and other documentations that I refer to, and the CMS rules. And I strongly suggest that you review this carefully. If you know anybody in the profession, a neighbor or a relative, I would ask them their opinion before this huge change takes place, and people like myself have to start re-explaining why they have a person who's not qualified working with their child. So thank you for the opportunity, and if you have any questions.
Representative Rhodes?
Thank you, Mr. Chairman. I actually don't have a question. If I could just have 1 second, that might clear up a few things. Actually, just one thing. You had mentioned Medicaid to schools a lot, and prior to me being elected to be a state representative, I actually worked in the special education department at a local school district, and one of the jobs I had there was actually being the Medicaid coordinator. God help me. And
Yes.
For those of you that don't know, the testimony that she gave is actually, very much correct. That you did have to have, these professionals had to be licensed in order to sign off on these special education services in order for the schools to be reimbursed. And then I believe, I want to say it was 3 years ago, it was at least 2 years ago, that there was actually a massive change that was made to the Medicaid to Schools program, where it was no longer able to just be, the speech pathologist signing off on the paraprofessionals or her coda. It actually became where you actually had to have a doctor or a registered nurse practitioner signing off on these IEPs. And yes, it created a little bit of confusion. So just wanted to kind of clarify that a little bit. The question was, would you agree that is now the I tried to say in the beginning, it was more of a statement. Would you agree that has created some confusion for the Medicaid to Schools program?
Well, yeah, bless you for doing that job, because doing Medicaid to schools is completely confusing. Yeah, I would agree with what you're saying. I also am a Medicaid provider as a private practitioner. I have a lot of experience with commercial reimbursement for people that come in for treatment through their commercial insurance companies. I forgot to add that a license with the different background, how is that going to work when they require a commercial insurance company, Medicaid enrollment as a provider in the state of New Hampshire? Well, I'm licensed and I have other, my other certification, but how is that going to be delineated for somebody who's licensed with the undergraduate degree? How is that going to be able to be, I'm just bringing it out rhetorically, but how is that going to be monitored? I realize that the amendment has some really good safeguards in place, but I've been on the licensing board. I mean, even that's hard to monitor people. So,
If I may, Mr. Chairman, I'm not exactly sure if I'm certainly not an expert in this field. And unfortunately, our school that I worked with ended up doing away with the Medicaid to Schools program. But if I'm not mistaken, basically what happened with the other schools in the area that kept it, they actually hired registered nurse practitioners to come in, or some physicians. Some of them actually came in. Our school meets on Tuesdays for their special education meetings. So those particular professionals would actually come in and sit for the special education meeting, and therefore they'd be able to sign off that yes, these services are required, is basically how it ended up going. And then after that, other schools are basically emailing and or faxing the IEP to the medical professional. They're signing off that yes, these services are required, and then from there, I believe that in this case, the speech pathologist is then able to sign off saying yes, they received the services that this doctor has agreed is needed in order to be reimbursed for the Medicaid to Schools program. Did I answer your question?
well, partly. First of all, I think the Practice Act for speech pathology allows the speech pathologist to not require an ordering physician. Although I have to take that back. That's Medicaid, they do. So they need to have the PCP, as I'm thinking. That's correct. Other commercial insurances don't. What I was bringing about is that now that if the undergraduate person is licensed as just a licensed clinician under the governing board, that gives them the credential to not just do Medicaid, sign off on Medicaid to schools, and actually you're saying that we need to have the physician anyway, no? Okay. Well, anyway, my other point on this is, aside from Medicaid to schools and working in a school, if the license is convoluted, that you have a speech pathologist who has the graduate degree of the highest level degree, and then you have a licensed speech pathologist who has an undergraduate degree that has minimal requirements to be able to fulfill the job, and a degree in reading or something, how is that going to be delineated to the public if they both have a license? I don't have to show my license to anybody. It doesn't have a special color to it that says I've got this degree and this person doesn't have that degree. I have to provide that license number through other means and then they can verify it. But that's a lot of red tape or layers to go through to prove that somebody's actually licensed with a qualified degree. And I think I don't know if anybody's provided the qualifications for the master's level degree. I don't know if there's time to do that after this committee. I can certainly do that. I've actually put things together very quickly. I work like 5 days a week, 12 hours a day. And I've got typos on here that I'm going to fix up and give back to you, and I'll give you these documents. But those are the questions that I have, and the reason why I have them is because those are the questions that I had to answer and find out about, and I know that people will be coming into my office asking me, what does this mean? And it's something to be strongly considered before agreeing to this and finding out exactly how it will affect everything with the consumer. And that's what the licensing board is about, to protect the consumer. Any other questions?
I appreciate your testimony
Thanks.
on this matter. Thank you.
Thanks.
If I can have a moment with Representative McGuire, no one's going to be shocked here that I have a direct line to the Chairman of Health and Human Services since he's my father. And they are willing to take this bill. This to me appears to be not really about licensing, but about qualifications under a license. So we should have a discussion. The chair calls Representative Marsh.
Thank you, Mr. Chairman. I apologize for not having written testimony. I was not originally going to testify, but I decided I needed to. I am speaking in opposition to House Bill 1016 as originally drafted, and in support of Amendment 0091H, which was my attempt to rewrite the bill. And I'm going to tell you guys a story. I can't believe how old I am. 34 years ago, my oldest daughter was born in Wolfboro. And like most young parents, we brought her to the public school to begin her educational process. When Becky went to public school, I'm sorry, I didn't intend to put her name into the record. When my oldest daughter went into the public school, the only person in the world who could understand what she said was her older brother. She worked with a speech specialist at the school over the course of her first year there in kindergarten. And at the end of the year, she really had not made any progress, and we were given the choice of the IEP process. And we said no. We removed her from the system. We found ourselves a speech-language pathologist in Sanford, Maine, who had the credentials, who diagnosed my daughter as having an exceedingly rare condition known as speech apraxia, and she worked with her over the course of a great many years. At the end of the time, my daughter we graduated her from homeschool. She went to Connecticut College, where she graduated on the dean's list. She now runs her own business in the state of Massachusetts. She does theater lights, and she's a fully functional member of society. I did that entirely on my dime. We didn't ask for the taxpayer's dollar to do that. It's important to me that we protect the credential of speech-language pathologists because I needed to find someone with qualifications to help my daughter. And the school didn't do that. And the person in the school is capable of taking care of all sorts of things that were fairly common that she had had experience with, but she was not a fully qualified individual. The speech-language pathologist eventually went on to become the speech-language pathologist at our local hospital, where I'm a trustee. And there are now many more speech-language pathologists in the state of New Hampshire than there were at the time. My daughter's 34 now. Like I said, I can't believe how old I am. Consequently, I worked with Attorney Adams and OLS to redraft the bill in a way that would preserve the speech-language pathologist credential, would allow us to not violate the interstate compact, which has now become established law in the state of New Hampshire, and would allow speech-language specialists to continue to do what they are doing. They can take care of common things, and they are providing a service in the schools, but they are not speech-language pathologists, and we need to recognize that. And with that, I'll conclude my testimony, and I'll be glad to take questions.
Thank you, Representative Marsh. Representative Lekis.
Thank you. So I'm glad things worked out for your daughter. My question is, would this amendment end up requiring that the people providing speech therapy in the schools be, you know, the fully qualified speech language pathologist? Because if so, my question is, if the people who were in the schools at the time your daughter was having the issue are qualified to handle most things, would it be appropriate to require all of them have greater qualifications when it might be possible? Maybe the school should have arranged something else for your daughter to find an appropriate person to help, but if they're not needed for the vast majority of the kids with problems, is that really the right thing to do?
I think that's a fair question. I do worry about misdiagnoses. I mean, not everybody has the wherewithal to basically stick their finger at the system and take it under their own responsibility. I'm very happy for my daughter that we were able to do that for her. And I worry that there are others in this world who could have been in the same situation and not had that opportunity. We tried to strike a compromise such that the people who are currently working in the schools would be able to continue working in the schools, but that new hires would have the credentials that are now much more available than they were at the time, because that seemed like a reasonable compromise. I'm certainly amenable to hearing some other amendment if you have some better compromise you wish to propose.
Thank you.
Representative Fellows.
Thank you. Representative Marsh, can you, it seems a little confusing to me that this language talks about issuing a speech language pathology license. The title says speech language specialist, and then the first one says the board shall issue a speech language pathologist license. So,
Representative, if you could give me a page and line of what you're referring to, then I could refer to what you're referring to.
this is at the very beginning of the bill. You know, it's line 3.
The bill as drafted?
Introduced.
Yes,
That's the only thing I have a copy of.
I'm sorry, I have more amendments in my folder, and perhaps Representative Schmidt will hand you one. I passed them out to the committee earlier today, but perhaps you weren't here at the time and I didn't get you.
Well, let me see if I can put it this way. So, do you know the degree requirements for a speech language pathologist? Does that require a master's degree?
There are people in the room who can answer that question better than I, and yes, there is a difference in the credentials.
Okay. So,
Follow up.
yes, thank you. So, since I saw nodding heads, if we're going to issue, it doesn't make any sense to me that, I don't even believe is there such a thing as a bachelor's degree in speech language pathology? I'm just thinking that it's probably a master's degree, but I don't know. That's my dilemma.
I agree with you that the language in the original bill was incredibly confusing, and that was one of the motivations behind my amendment, which I think you now have in front of you.
Thank you. I will have to study this amendment to see if I can figure this out. That'll take a while.
Does anyone else have a question for Representative Marsh? Seeing none, thank you, Representative Marsh. The chair calls Victoria Chesterly.
Madam Chair and members of the committee, thank you for your consideration of the amendment to HB 1016. I'm a resident of Nashua. I've been a speech language pathologist since 1976. I have served on the New Hampshire Speech Language Association's. Oh. Is that better? Okay. I've served on the New Hampshire Speech Language Association's Executive Board as President, Treasurer, Academic Advisor, VP of Governmental Affairs, and I've also served as a speech language pathology member from New Hampshire on the ASHA Advisory Council. My most recent employment was as the director of the SLPA program at Nashua Community College. I've also worked in schools, hospitals, both acute care and rehabilitation and home care. I'm currently retired, and I'm not representing the New Hampshire Speech Language Hearing Association in this hearing. I am representing myself as a private citizen. The memo that Laura referred to was a prototype that I wrote as an example when I was working with the VP of Governmental Affairs, Neil Thamia. I think I said his name wrong, but if you have a copy of that, please discard it. I did circulate a letter from me as a private citizen. Okay. The issues that I'm hoping will resolve by the passage of the amendment to HB 1016 are consolidating the governmental oversight of all individuals providing speech-language pathology services in New Hampshire into the Office of Licensed Allied Health Professionals. Having two agencies dealing with the same profession has caused confusion to the public and to the profession. Passing this bill would also relieve the Department of Education from the necessity of requiring licensed speech-language pathologists to also hold the speech-language specialist endorsement and the associated monitoring of that endorsement. An issue that arose was the conflict with the Audiology Speech-Language Pathology Interstate Compact, which was passed when this initiative was being developed. It is exceptionally important that New Hampshire comply with the requirements of the compact, and the American Speech and Hearing Association has suggested that a new license be issued for speech-language specialists so that it would be a speech-language specialist license administered through the Allied Health Office of Licensed Allied Health Professionals. By using the alternative title, the individuals holding that license would automatically be excluded from any participation in the compact. The underlying issue is having two governmental bodies dealing with the same profession. In, I think it was 2017, the Department of Education had a subcommittee that worked on updating the rules for speech-language specialists. And the goal of that committee was to make the rules for the speech-language specialist equal to the requirements for a speech-language pathologist. At that time, the main difference is that the speech-language pathologist has to take a national exam, and I don't believe the specialists do. However, the individuals that we are trying to move over to Allied Health have been in the field for 20, 30, 40 years, and the new requirements didn't affect them. Anyone coming along now would have to meet the new requirements, and I believe that most people would go for the license, especially if we eliminate the Department of Ed credential. An issue that arose today was the Medicaid to Schools program, and I believe that they have changed the rule so that speech-language pathologists can sign off and order services, speech-language services. That was quite an issue, but I think they fixed it. I'm not sure that I said this, but the memo Laura was referring to was not submitted. And if you do have it, please discard it. It was something that the VP of Governmental Affairs and I were working on together, and he has submitted his own memo on that. Any questions?
Representative Fellows.
Thank you. Do you know if there's, the Department of Education still has a certification for speech language assistant?
No, the Department of Education never had an endorsement for speech language assistance. That was always done through the Office of Allied Health,
Done through what?
OPLC.
Oh, thank you.
Does anyone else from the committee have a question? Seeing none, thank you, ma'am, for your testimony.
Thank you.
The chair calls Steve Appleby from the New Hampshire Department of Education.
Good afternoon, representatives. Thank you for your time this afternoon. For the record, Stephen Appleby, Director, Educator Support and Higher Education.
Could you
Closer.
spell your last name? We didn't catch that.
Yes, last name is Appleby, Appleby. Okay. Yep. One of the programs that I am responsible for is educator licensure in our K-12 system. And to that end, I'm here to address strictly Department of Education related questions. Just some quick facts and figures for the committee. We currently license over 28,000 educators statewide in positions ranging from para-educators to superintendents. We have approximately 88 different endorsements that we license. Of that over 28,000, we currently license less than 60 speech language specialists. And when we looked at this issue and analyzed it about 18 months ago, when the Medicaid to Schools issue was a very big topic, what we found was our SLS base, of that less than 60, less than 20 were not speech language pathologists. And that less than 20 number, the average age was over 60 at the time. One other piece of information, every year I receive numerous phone calls, as does the Bureau, asking why, this is a speech language pathologist calling us, asking why they have to pay the Department of Education for a license as well as OPLC for a license. So we support moving this entirely to OPLC in whatever form that takes. We're not medical professionals, we're educators. But the follow-up question to the dual licensure is always, well, physical therapists and occupational therapists don't need an education license. Why do I? So hence the support for moving this to OPLC. Happy to take any questions.
I have one for you, because I have concerns about us operating in the state with speech language pathologists and speech language specialists. I'm confused as hell by it. I can't imagine how someone from the general public's going to be. How does the Department of Education, what would the Department of Education look for? What would you guys be using? Would you be looking for pathologists or specialists?
So we have not licensed a new speech language specialist that was not also a speech language pathologist in many years. Predates my time coming to the department. So the only folks today getting licenses from the Department of Education are already SLPs. And as evidenced by our administrative rule, which states that, here's a list of competencies to be an SLS, or if you have a valid speech language pathologist license, we will take that in your fee and we will issue you a license as an SLS. So we don't see an influx of folks coming in to get an SLS license who aren't already an SLP. So I guess what I'm saying here is it's redundant at this point.
Okay, thank you, Representative Fellows.
Thank you. So So the schools want to employ speech language pathologists, and you would like to see them be licensed by OPLC. Don't you also need to certify them? Because one of the things we heard in an earlier bill is that OPLC doesn't do or has difficulty with, doesn't know how to really have good ideas for handling background, criminal background checks, which is very important in schools. So how would you make sure that they don't have that criminal record, so you don't want them in schools? Thank you.
Thank you for the question. Up until this past legislative session, we did not criminal record check license holders. Whether it was a first-time license application or a renewal, the Department of Education did not criminal history check those individuals. We used to, and then in the 1990s, for some reason, that was dropped and pushed off on the districts. So the statute that has existed now for many years is that the district is responsible for the criminal history records check. There was legislation that passed in the last session that tasked the Department of Ed with also performing a criminal record check for all new applicants, and that will go into effect once the FBI authorizes us to receive the record. But that has not happened at our level for decades. So your question was, what about criminal history record checks? That is performed at the employment level by all districts. It is the law. And the Department of Education is phasing back in performing it on licensees. But today, we don't do it. So the law went into effect January 1st. However, the FBI has not given Department of Safety permission to release the record to us. It's imminent. We're hoping in the next few weeks we get that record, that approval, because it's the FBI record. Right.
Yep, follow up.
So let's pretend everything goes as planned in 2 years from now. Do you want us to delete, well, it says speech language specialist. Should you have speech language pathologists in this section about licensing?
No, we don't believe so, because again, we would be dual licensing one individual. And the feedback we have received from the field is practitioners do not see the need to pay 2 different state agencies for 2 different licenses to do the same thing. Additionally, the criminal history record check, which I understand the concern about OPLC, but I can assure you that the districts, by state statute, also must perform a check before that person can be alone with a child.
Is DOE going to start doing criminal record checks on new?
Yes.
Including speech
Any new applicant for any endorsement that we offer. But that is strictly related to the license, not the employment.
Yeah, one more, Representative Fellows.
So does that mean schools will employ speech language pathologists, but there will be no certification of those positions by the Department of Ed?
That would be the effect of this legislation. We would no longer certify speech language specialists who may or may not be a pathologist.
Speech language, okay.
We don't license speech language pathologists today. The license that Department of Ed gives out is a specialist license, which, if you are a speech language pathologist, you are automatically granted the license because you meet the requirements.
So, okay, so that sounds to me like a unique situation for people who are employed by school districts.
I'm not sure.
I don't know that you could speak to that.
I'm not sure I understand the question. Yeah.
Because it's beyond your scope. Representative Lekis?
Thank you. Just to make sure I understand correctly, the background checks, criminal background checks are done by the districts and are going to be done by the DOE, are going to be done for anybody working in the schools, and it's not tied to particular licensing. Is that correct? I mean, so what I'm getting at is let's say OPLC may or may not do any kind of criminal background check for the speech language pathologist, and you're not going to be licensing them. But regardless, is it true that for them to work in the school, there's going to be a background check done?
Yes, thank you, Representative. Yes, that is correct.
Okay, thank you.
Does any other member of the committee have a question? Seeing none, thank you, sir.
Thank you.
Is there any other member of the public wishing to testify? If you could come forward with your pink card, please. Two things. One, I would prefer you bring it up now if you could for the clerk. And the other one was the microphone, but you seem to have found that.
Yes, thank you, Mr. Chairman, and I'll be very brief. For the record, my name is Tom Praisall from Demers and Praisall, here today representing the New Hampshire Speech Language Hearing Association. And I just wanted to address a couple points. When this bill was initially drafted, it came from language that NISHLA had provided to Representative McGuire. After that was submitted to the Office of Legislative Services, NISHLA has worked with ASHA, the American Speech and Hearing Association, to draft language. And that is the amendment that Representative Marsh so kindly drafted from OLS. So I think, everybody here would agree that we should focus on the amendment and not the underlying bill. So I want to start off with that. And second, I just wanted to, I think the point was raised, which is that there's currently 2 licenses, right? And if you're a speech language pathologist, you're automatically a speech language specialist, so there's no need to move forward with the speech language specialist license, which is what the amendment does. If you see it, when you read through, which I understand most of you just got it today, you'll see it essentially phases out the speech language specialist license. So I understand this bill is going to subcommittee, and I'm happy to work with the committee through that process, but I was just trying to hopefully simplify. I know there's a lot of confusion between SLS, SLP, SLA, a lot of that. So just trying to, simplify things a bit. And with that, that's all I have to say. But I'm happy to work with the committee during a subcommittee.
Thank you, sir. Does any member of the committee have a question? Seeing none, thank you, sir, for your testimony.
Thank you.
It's up to you. I'm not going to force you to testify. I'm just giving you the opportunity.
Try to wrap up by 6.
I know, I think I've spent the whole day with you folks. Lindsay Courtney, Executive Director, OPLC. OPLC would support any legislation that would eliminate unnecessary duplicate licenses. I can't testify to the board's position on this particular legislation, but we certainly shared the initial concerns of the bill as proposed, but we support the amendment. I'd be happy to answer any questions. I know that a question came up regarding criminal records, history records checks. The Speech Language Pathology Board does currently require initial applicants to undergo criminal history records checks, so that's currently being done. Happy to answer any of the questions.
Representative Sitek?
Yeah, might as well go for it. This is actually a question for, is Mr. Appleby still here? Oh, there he is. You said you're waiting for the FBI to check, to release. How come the local school district can do a background check, but the Department of Education has to wait for the FBI to do something? This is weird.
Thank you for the question, Representative. The FBI is very particular about their approvals for release of their records around criminal history checks, so they must approve all legislative changes. So there is already in our statutes enabling legislation that the FBI has approved for school districts. But that language did not exist for the DOE to receive the record. So that's what we're waiting on.
How thin can you slice the bologna?
Well, with that, if anybody else from the committee has any questions, seeing none, I will close the public hearing on House Bill 1016.